The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Okay, thank you. We're ready to proceed in the case of 17-3, United States versus Dylan Roof. Ms. Merchandani, you're the first arguer, right?
Yes, thank you.
Please proceed.
Okay. Good morning, Your Honors, and may it please the court. My name is Sapna Merchandani, and I'm here with my colleagues Alexandra Yates and Margaret Farrand, appearing on behalf of appellant Dylan Roof. This morning, I would like to address the competency issues that are presented in Roman numeral sections 3, 4, and 5 of the opening brief. Afterwards, my colleague, Ms. Yates, will address the self-representation issue under McCoy versus Louisiana in section 8 of the brief, and then the future dangerousness issue in section 15 of the brief. If time remains, Ms. Farrand, Ms. Yates, and I are prepared to address any other issues about which the court has questions. So turning to competency, we've raised several challenges to the district court's handling of the issues related to Mr. Roof's competency to stand trial, including a challenge to the merits of the court's decision finding him competent to proceed. But for purposes of argument this morning, I would like to focus the court's attention on the district court's exclusion of critical mental health evidence from the second competency hearing sentence competency hearing before sentencing. This was section 5 of the brief. The court barred testimony and reports from 4 mental health experts establishing that Mr. Roof suffered from a delusional belief that his trial did not matter because he would be freed by white nationalists after they prevailed in a race war, but only as long as he appeared pure, which he defined as not suffering from mental illness. Now, the court, in blocking the evidence, committed an error of law by applying the law of the case doctrine, which applies to legal rulings, not factual determinations, and blinded itself to evidence on the fundamental issue of whether, in fact, Mr. Roof was suffering from a delusional belief or was acting simply out of prejudice.
Can I ask you a question, Ms. Merchandani, and about the standard of review to start with? What's your contention about the standard of review here on these competency decisions?
Well, there's 3 different competency issues. The first 2 are, well, 2 of them are procedural, which is an abuse of discretion standard, which is the failure to give more time for the first hearing and the exclusion of evidence at the second hearing. But for the substantive decision, it is a clear error standard.
Okay, so on that point, since there's conflicting evidence about competence, I mean, you'd agree that the record contains evidence from experts saying, oh, he's competent. If it's a clear error standard on that substantive component and there's conflicting evidence, how can you win? How can there be clear error?
There can be clear error, as this court found in U.S. versus Antone and U.S. versus Wooden. And in both of those cases, they didn't deal with competency. They dealt with whether or not a defendant was a sexually dangerous person under the Adam Walsh Act. And in both cases, there was expert testimony on which the court relied to find the person either dangerous or not. But the court didn't address substantial contrary evidence going the other direction. And that is what happened here. So yes, there was one, you said experts who said he was competent. There was only one, Dr. Ballinger, who had never performed a competency exam before and whose evaluation was inconsistent and actually in some ways supported our argument that there was a...
Are you asserting that Dr. Ballinger is not competent to be an expert?
No, I'm not saying that.
Okay.
I'm not.
So if Judge Gergel hears Dr. Ballinger and he hears Dr. Ballinger say, and I think what he said was that Roof was not controlled by mental illness, but had a logical extension of his political and social beliefs in doing what he did. If Judge Gergel hears those things from somebody who's competent to render an expert testimony, on what basis would we say that's a clearly erroneous judgment by the district court?
It was clearly erroneous because the court did not address any of the substantial contrary evidence, which was 5 experts who said that Roof had a history of suffering from delusions, both race war delusions and somatic delusions, medical records documenting years of suffering from these delusions, Dr. Ballinger admitting that he hadn't reviewed all of those records, never addressing them. So Dr. Ballinger's opinion is worth what it is, but he only addressed what Mr. Roof told him after November 7th and before November 22nd, which was during the period of time when Mr. Roof had gotten wind that his mental illness would be publicized, which would thwart his eventual rescue by white nationalists. And at that point, he started covering up all of the delusions that he had previously spoken about. So the court committed clear error by ignoring 9 months of statements that are very consistent, documented by 5 different experts and defense counsel. Defense counsel, 3 attorneys did a sworn affidavit talking about
just ignored it. The district court just ignored it. It's not that the district court's opinion can be read as saying, I believe he's competent. I believe this expert.
Well,
You think that the record is so clear that the district court just ignored it, that it constitutes clear error. That's the legal position you got, right?
Well, my legal position is that it ignored it actually at the second hearing, where the court declared it was not going to consider any of these medical reports. So yes, that it was an abuse of discretion to block the evidence, and it resulted in a clear error because it substantively ignored evidence. At the first hearing, it didn't exclude evidence, but what the court said was, after hearing from all of these experts, Ballinger, Stayskull, Maddox, and Ballinger, yeah, the court said only one defense expert said that Mr. Roof is incompetent and relied on Maddox. But that was not the case. Dr. Lofton submitted an affidavit saying that Mr. Roof did not fear death sentence because he did not believe he would really be executed. He emphatically believed he would be rescued after the race war. Dr. Stayskull said the same thing. He said, although he needed more time to reach the ultimate issue of whether or not Mr. Roof was competent, he had deep concerns because he saw evidence of a schizophrenia spectrum disorder based on this history of delusional beliefs that he had, and that he did not seem to take seriously the threat of death. And the court did not address any of those in its first decision. In the second decision, it didn't even consider them.
Well, counsel, let me interrupt you. I've got to interrupt you. I don't mean to interrupt Judge Jordan there, but the judge said, Joint Appendix at 5529, he, quote, read every one of their experts, and that's at the second hearing, right? He says he read every one of them. He also says that Ballinger reviewed all those reports and discussed them with Roof. And I know that he makes the statement about law of the case, and that's probably better applied to legal conclusions. I get that. But what about his blanket statements about reading it? And these experts did not examine him, right, between the first and second hearings? So help me with these simple facts.
The defense experts did not examine him between the first and second hearing, but the reports contained historical information about the history of his delusional beliefs, which is very important in deciding if somebody is competent. It's not a snapshot of what the person looks like today. It's a factor, but what also matters is the history of the person's medical history and mental.
Well, wasn't the district court judge concerned, and maybe rightly so, that the defense was just looking for a do-over? That there was no new information. This was just wanting another bite at the apple. There wasn't, as Judge Benton pointed out, there wasn't new information that was being brought to bear from re-examination. This was just the experts coming back with, as you say, providing maybe some more historical information, but rendering additional opinions. And the judge said, you know, perhaps the wording was inartful, but speaking in terms of law of the case, can that be understood as the district court judge merely saying, we've been down this path and we're not going down this path again because I've rendered my decision?
Well, that goes back to what Judge Benton asked, which is, excuse me, the comment that the court made that it had already read all of those reports. it couldn't have read all of those reports. It said, I read all of these at the first hearing, we've already been through it. The reports did not exist at the time of the first hearing. They were only completed on December 28th and December 30th, just before the January 2nd hearing. Same with Dr. Ballinger, who said that he had considered all of those reports and took them into account at the first hearing. Again, the reports did not exist. He later corrected himself and clarified that he didn't because he couldn't have. Now, yes, both the court and Dr. Ballinger said they read those reports, but there's no evidence in that from the court's opinion. The court's opinion focuses on what Ballinger said and what Mr. Roof himself said. And
Well, we could probably fairly take Judge Gergel at his word if he says I read them, couldn't we?
we could, but
Okay, so if he read them, then isn't it fair to believe he also considered them? Not that he read them and immediately blocked them from his mind, but he read them and he considered them.
no, because in Antone, or actually it was in Wooden, no, I'm sorry, it was Antone. The court mentioned evidence that was not substantively weighed. It talked about evidence that was heard. So yes, even assuming the court read the reports, what matters is that the evidence was not weighed against each other. So what this court said in Antone is, the government contends that the district court's consideration was sufficient because it adopted the factual findings, even though the district court acknowledged its awareness of the testimony. That by itself does not indicate that it adequately considered its impact. So yes, the court said, I read the reports, but if you look at the court's opinion, there's no reference to, and it wasn't just a repeat. Dr. Moberg submitted a report, a very detailed report that contained neuropsych testing that had not been presented at the first hearing, and craniofacial measurement testing showing disruptions in Mr. Roof's cranium that indicated that he was suffering from schizophrenia and related disorders. He said that he had a frontal system, a brain dysfunction with psychosis spectrum features, and that he suffered core components of a psychosis.
Well, nobody's suggesting that you don't have evidence in support of the position that you took. At least I don't think so. And I didn't even understand the district court to be suggesting you didn't have evidence in support of the position that you took. I understood the district court's position to be the court was more persuaded that Mr. Roof was competent than that he was not competent, and that he was persuaded on that after having read the reports and in the first instance having heard the experts. So you certainly got evidence you could keep reciting, but I'm trying to circle back on the standard of review here and the clear error point, and I guess your assertion is because it wasn't laid out in some detail in a written opinion, that shows a lack of weighing, and that represents clear error. Is that it?
The lack of weighing, and in this case, yes, the lack of weighing is what happened in Antone and Wooden, and that gave this court, it didn't have any faith that the evidence was substantively considered. So you can say, I've admitted these reports, I've looked at this, but if you look at the court's actual decision, he quotes at length from Dr. Ballinger, who had not at that point, had not spoken to Mr. Roof before his competency was in question. So at that point, there's evidence that he was masking his mental illness to be saved. Also, Dr. Ballinger had not had the benefit of having any of the evaluations by Dr. Lofton or Maddox or Moberg. Now, that's important because at the second hearing, one of the reports that the court rejected and refused to consider was Dr. Maddox's, in which she went back and compared all the different evaluations and talked about how Dr. Ballinger's evaluation had glaring holes because it ignored this history of delusional beliefs. So Dr. Ballinger.
Oh, hold on, because when you talk about a history of delusional beliefs, is there a conflict here a little bit in what you're saying? Because part of what I thought in your reply brief that you were faulting the government for relying on Roof's late 2016 statements about a race war only after he learned about what counsel was going to do, is sort of a assertion that there was a focus on things that happened when when Mr. Roof decided, oh, they're going to embarrass me, and then he started doing something. But the court had before it evidence from that very first confession, right? When the FBI was talking to him and he said, I'm not delusional. I don't think that something like what I did could start a race war or anything like that. I mean, he was in that very first interview saying to the FBI agents, you know, I wanted to make a statement, but I didn't think I was going to start a race war. And I thought that would be pretty terrible, et cetera. Now, he said, I think there might be one eventually. I guess my question to you is, there's evidence going right back to the start, right, with the arrest that indicates him taking a position that says, I'm not delusional about what's going to happen. I know what's likely to happen to me. I wanted to do something dramatic, and I did. Are those things in conflict with what you're saying when you say, the government's just focusing on this one thing, on this one part, after he thinks he's going to be able to hide his mental illness?
No, it's not inconsistent at all. What Mr. Roof said at his confession was, I wanted to increase tensions. I wanted to alert white people to the fact that they're under attack and will be eliminated if they don't fight back. And he said, I didn't think I was going to start. I know that wouldn't have started a race war, but he said, inevitably, tensions would increase such that there was this inevitable war going to happen. And what he said to Dr. Moberg, which was not considered by the court, was that as of February, he was 80% sure that this race war would happen and he would be freed.
And now, does that make him somebody not competent to stand trial? It makes him certainly indicates he's a person who's full of hate. It certainly indicates that he's a person who is horribly motivated. But is it, maybe the best way to answer this question is having despicable opinions and forecasts the same thing as incompetency in the legal sense to stand trial, to be able to assist in one's own defense?
No, it is not hatred. It is not his opinions. It is a delusion. Now, a delusion by definition is a fixed false belief that cannot be moved by objective contrary evidence.
Counsel, I've got to jump in, and I'm sorry to interrupt your sentence. I hate to do that, but you used the word fixed. Now, at times with these experts, he laughs at some of this stuff, right?
Well, the only time he laughed was with Dr. Ballinger. At that point, he was trying to present himself as not mentally ill.
Right. But that's my point. It doesn't seem fixed when he has several of these. And of course, we all know what his IQ's tests are. They're very good, as you know. So I think that the word fix there, you might want to dwell on for a moment, because I think that is the key to your argument, or its undoing. Go ahead.
It is. I don't think it's the key to the undoing. I think the evidence shows that until November 7th, he consistently said the same thing, which is there is going to be a race war. This leads back to Dr. Lofton's report, which was omitted from the second hearing, another instance of the abuse of discretion, where people who were interviewed, people who had known Mr. Roof long before he committed the crime, and he would talk about a racial revolution and the certainty of white people going extinct. His stepmother said that he was getting a gun to prepare for the coming revolution. So everything that he said up until November 7th is of the same piece. It is preparation for something horrible that was going to happen, and that he wanted to help because it would wake white people up. It's despicable.
Is every neo-Nazi incompetent to stand trial?
No.
Because that's what it sounds like you're saying. It sounds like what you're saying is, if somebody believes that there will, and Roof's exact words were, there probably will be a race war eventually. That's what he said to the FBI. That's a quote. If everyone who holds that belief is incompetent to stand trial, then isn't there a little bit of a problem that we've taken a whole range of people who might commit violent acts out of the system because they just can't be prosecuted because they're all they're all delusional and incompetent?
No, I think the word delusional gets thrown around and it's used colloquially. This is actually a medically defined term that multiple experts said applied to him because he acted on it. It wasn't just a belief. It wasn't just an overvalued racist view. He acted upon it and he was convinced. We know that because he tried to fire his counsel on the eve of trial and wrote a letter to prosecutors. And let's be really clear about how unprecedentedly bizarre this is. He wrote a letter to the prosecutors on the eve of trial, telling them that the attorneys that he had been working with for 16 months were liars and that nothing they said could be trusted. And then he told Dr. Ballinger that he felt like he was sitting at the wrong table in the courtroom. He felt like he was on the side of the prosecutors. His delusion was so fixed and so strong that he thought it better to be on the side of the prosecutors and to have a clear picture of mental illness for the future white nationalists than it was to persuade even a single juror that his life was worth sparing. Now, that is neo-Nazis.
So it's not, I mean, it might be difficult for you or for me to be thinking I would value my public reputation above my life, maybe, but that's what you're attacking as being delusional, that he believes I'm not delusional, I'm not mentally ill, I don't want a mental illness defense. I'm absolutely opposed to that. My lawyers won't listen to me when I say I don't want that defense. They continue to press it, and I'm not happy about it. And I'm trying to grapple with this. Is it not possible to disagree with your own lawyers on a defense strategy without having your lawyers declare you that, look, this is further proof that you're delusional. You don't agree with us. You must be crazy.
No, and this is exactly, we are not saying that at all. That is taking the argument far too far. What the district court said very similarly was, if every defendant who disagreed with his attorneys decided he didn't want to cooperate anymore, was delusional, nobody would ever be tried. That is not this case. We have here a history, and not just the year before the crime, but a lifetime history of neurological impairment and psychiatric disorders, obsessive compulsive disorders, paranoia, grandiosity. He believed that he was going to save the white race. These are all things that even Dr. Ballinger noted. He did not label them grandiosity and paranoia, but these had been with Dylan, Mr. Roof, his entire life. When he was 8 years old, he thought the clouds moving were sending him a message that something bad was going to happen. When he was even younger, he had to do things precisely 3 times. He had to kiss his mother 3 times. He had to say he loved her 3 times. Now, all of those do not make him delusional. No, I'm not saying that they do.
And they don't make him incompetent either, right? I mean, you've just
incompetent.
listed a whole bunch of things that are mental illnesses.
Which,
or signs of mental illness, but you'd have to agree, wouldn't you, that being mentally ill is not the same thing as being legally incompetent?
exactly. Burkett and versus Angelone and Beck versus Angelone are cases in which the person was severely mentally ill, but not incompetent. What makes a person incompetent is when they are unable to reasonably consult with a lawyer with a rational the rational sense of what is happening. Now, the irrationality is the basis of Mr. Roof's refusal to consult with counsel.
Well, his refusal was not that he wouldn't consult with counsel, it's that he wouldn't consult with them and help them and aid them in making and mounting a mental illness defense. Isn't that where the breakdown was? Can you point us to something in the record that shows a breakdown in communication that was not related to the defense counsel's desire to mount an insanity defense?
Well, yeah, the rupture happened when Mr. Roof learned from Dr. Dietz that there was going to be a mental illness defense, and that was the rupture. At that point, he stopped cooperating at all. So
I'll repeat the question. Is there any other thing in the record that shows he was not cooperative, he was not willing to engage, he was not actually talking with them until the trust broke down from his perspective, apparently, because there was a decision we're going to go with an insanity defense, and he didn't agree with that. Is there anything else that shows he wasn't cooperative or able to assist?
This wasn't an insanity defense. What the attorneys were going to do was present mental health evidence as mitigation in the death penalty phase.
Right.
No, yes, Mr. Roof shunned all mitigation evidence. So he had family members, a pastor, people who had known him his whole life, who had known that he was nonviolent and that he was strange. I mean, every single person who had known Mr. Roof, there were 80 interviews summarized in Dr. Lofton's report, which was again excluded from the second hearing. 80 interviews with people, teachers, coaches, ministers who had known him his entire life, who said that he was a loner, he was weird, he was robotic, he was numb. Now, all of these things, but he was gentle until he went through this prodromal phase of this schizophrenia, of this psychotic spectrum disorder, according to all the people closest to him. In the 2 years before he committed the crime, between 2013 and 15, is when he became even more isolated and committed to this idea that he had a special mission, which is what he told his counsel, that he had a special mission and that only great people in history have a mission. And he was one of those people, and he was going to save the white race. Now, that was a break from how he had been before. But again, these are all part of what makes him incompetent. So it's not just a delusion. It's not a paranoia. It's not OCD. It's not all these things. It's the full picture, which is where the medical experts came in and said, this is an entire rich picture of a lifetime of neurological impairments and psychiatric illness, which coalesced right before the trial with this break. And it was a sign that he was incompetent. Now, the incompetence says you cannot rationally assist. And there are cases in which Lafferty versus Cook is one in which the 10th Circuit said the defendant was so besieged by his delusion that
and that was the case with hearing voices and things like that, right? I mean, but you've cited cases that we've looked at where there are people who are clearly psychotic. And in this case, there's a guy who's clearly got a whole range of significant mental illnesses and issues. But the record seems to indicate that he's very bright. He absolutely understands what's going on in the courtroom and he's working with his lawyers until he feels, rightly or wrongly, he feels betrayed by them and knows they're going to make him out to be a person who is delusional and crazy, and he doesn't want that. And I have looked, and I've been asking you for it, because I can't see anything else in the record that indicates that he's not helpful, he's not engaged, he's not working with them until he believes I can't trust them anymore, because despite what I want them to do, they're gonna put on mitigation evidence to show I'm nuts, and I don't want that. Well, now, if I've missed something, because this record is enormous, if I've missed something, that's why I'm asking the question I'm asking again. If there's something else in this record that shows, no, here's another point, another time, another issue on which there's a record that shows he couldn't help, he wasn't able to help, he didn't want to help. But it all seems to center around this one point, which is he says, I am not mentally ill, crazy, I'm not delusional. And the assertion you've got, which is he doesn't want to help his lawyers, and that is consistent with mental illness, and therefore he's incompetent.
No, that is not our argument at all. That because he is disagreeing with his lawyers. You said all those things about the person being clearly psychotic because he was hearing voices. Mr. Roof also talked about hearing voices. We do not have just a defendant who is not willing to work with counsel. We have a defendant who is guided, all of his decisions, according to Dr. Ballinger, are driven by the delusional belief that he will be rescued as long as he appears a pure and unblemished specimen, a perfect specimen. Otherwise, he would be subjected in the future to sterilization or elimination. Now, these are exactly the words that Dr. Ballinger used. It is not that he opposed a mental illness defense or mitigation because he thought it would bring stigma or opprobrium. He was opposed to it because it would thwart his rescue. That was the core. You can't separate the two. Even the court agreed that the reason he didn't want this was because he wanted to be saved in the future. If the
The
deletion,
timing, did the timing of this make any difference, Ms. Merchandani? There was the court seemed to be concerned that there was this second competency hearing request coming very close to trial, that this was going to cause a delay. There was some sense that, you know, maybe there was playing for time going on here, or at least one could read the district court's concern to include that. Is it unfair or improper for a district court to be paying attention to the schedule, to not allowing for delay that would prevent the orderly trial process to go forward?
no, it's important, and it is a factor, and is a factor to be balanced again with other factors. And the South Carolina District Court, in simple cases such as drug possession, when a defendant seemed to be incompetent, even on the eve of trial, the average amount of time was 4 months to prepare for a competency hearing. Now, counsel had 2 weeks. So yes, that is a factor, but a person's constitutional right to being mentally competent at their trial. Dusky and Drope, the Supreme Court discussed that you don't just want a defendant to be physically present, but they have to be mentally present.
Let me interrupt you. That does conclude your time, but
Okay.
if Judge Jordan wants to inquire further, you certainly may, Judge Jordan.
No, I know we've got a lot. We have a whole lot of issues to cover here, and I do appreciate Ms. Merchandani's assistant in fielding my questions.
Okay, seeing no more questions from the panel, thank you for your argument. Ms. Yates?
Thank you.
Good morning. May it please the court. My name is Alexandra Yates, and I propose to address 2 issues with the court today. First, I'd like to discuss why, if Mr. Roof was competent to stand trial, he also had the right to decide whether to portray himself as mentally ill, and he should not have been forced to waive counsel and represent himself at jury selection and the penalty phase of his death penalty trial in order to make that decision. And that is the point at Roman numeral 8 of our opening brief related to McCoy versus Louisiana. Second, I propose to discuss why this court should remand for a new penalty phase, because Mr. Roof's jurors were misled to believe that he posed a risk of future dangerousness because he might incite others to violence through use of the mails. It is undisputed that prisons have basic security measures that could prevent this sort of thing from happening, but Mr. Roof was precluded from telling jurors that fact. And that is the future dangerousness point at Roman numeral 15 of our opening brief. With the court's permission, I will begin with the McCoy issue. Your Honors, Mr. Roof, a then 22-year-old with undisputed mental impairments and no experience in the criminal justice system, didn't want to represent himself at his capital trial and never should have been forced to. He waived counsel for one reason and one reason alone, and that was to prevent his attorneys from presenting mental health evidence that he thought would ruin his reputation and undermine his chances, and undermine the reasons for committing his crime. Now, the district court, relying on then existing case law, told Mr. Roof he could have counsel or he could exclude mental health evidence, but he could not have it both ways. We now know from the Supreme Court's post-trial decision in McCoy versus Louisiana that this was wrong. Representation by counsel is not an all or nothing proposition, and a defendant need not forego the assistance of experienced attorneys in order to remain master of his own defense with the right to choose the objective of that defense, be it contesting guilt or avoiding the opprobrium that comes with admitting stigmatizing facts. Because Mr. Roof's main objective was to avoid admitting what he viewed as stigmatizing impairments, his attorneys could not interfere with it.
Ms. Yates,
Yes.
can you dive into McCoy a little bit with us? What's the difference between tactical decisions and defense objectives?
The tactical fundamental divide is a difficult one, and I think Justice Scalia talks about this a little in his Gonzalez concurrence. What we know from McCoy is that there are decisions beyond the right to waive jury, the right to plead guilty, the right to take an appeal, the right to testify, that courts have long talked about as fundamental, that are also fundamental. And one of those is the right to choose the objective of one's defense. And what the court in McCoy says is the objective of your defense can also be to preclude the admission or to preclude your side, your defense, from admitting certain facts.
Like that you're guilty, right? I mean, that was McCoy, right? McCoy is the defendant doesn't want to admit guilt. The lawyer decides admitting guilt is a good idea. It might avoid the death penalty, and so admits guilt repeatedly. And that's what moves the Supreme Court in McCoy, isn't it?
Well, McCoy is about factual guilt, not a concession of guilt. And it's about admitting certain facts. And we know this for a few reasons.
Committed the murders. I mean, the defense lawyer said 3 times in McCoy, the guy committed the murders. So that seems to be, and this is why I'm engaging with you on this, it seems to be that the Supreme Court is saying, look, there are some things that are just so fundamental that they're not exclusively the control of defense counsel. The defendant's got some say in it. But there are tactical decisions that are for defense counsel and defense counsel alone. So help us understand, or help me understand. I don't know, Judges Benton and Gilman may have this thoroughly in mind and understand it, but help me understand what is it about a mental illness defense or mental illness mitigation kind of defense that is equivalent to something as fundamental as admitting guilt, admitting that you've done the actus reus. How are those two things the same?
Right, so I would point the court to the Ninth Circuit's decision in United States versus Reed, and there they rejected the position that McCoy is just about admitting guilt. And this is at page 721 of the opinion. So the Reed case was about the defendant's right to refuse an insanity defense. And this defendant in Reed, he admitted his factual guilt, right? The point that Mr. McCoy wanted to contest. He admitted the actus reus of the crime, the killing. But he nonetheless objected to an insanity defense, and he objected to it for the reason that he did not want to depict himself as mentally ill. He did not agree that he was insane, and he did not want his side in this adversarial process to be saying that he was. And what the Reed court says is, sure, we shouldn't, choosing whether to present an insanity defense is in some ways tantamount to a guilty plea. And so we should allow defendants to make the choice for that reason. But that's not all of it, because even in a case where the defendant admits his factual guilt, he still may have concerns about the grave personal consequences separate and apart from the admission of factual guilt that can come with an admission of mental illness. And Reed cites a number of cases, both state and federal, that have long recognized the potentially stigmatizing nature of admitting mental illness. And I think this is consistent with McCoy, because McCoy—
Well, speak directly to the government's argument in their answering brief that McCoy did not hold that whatever issue is viewed as most important to the defendant becomes the defense objective that counsel must follow. That doesn't matter how strongly the defendant feels about an issue, that doesn't convert a tactical choice into the kind of defense objective that has the weight that admitting guilt does, and which was the centerpiece of McCoy.
We agree with that, Your Honor. Not every decision becomes a defendant's decision. What we know from McCoy is a couple of things. And McCoy says this at page 1508. We know that the decision not to admit factual guilt is so fundamental that belongs with the defendant. We also know that it is a fair defendant's objective to wish to avoid above all else the opprobrium that comes with admitting certain facts.
So how do we square this with the argument we've just heard from Ms. Merchandani, which is it is so bizarre, the defendant's attitude toward this as to constitute delusion and a fixed delusion at the level of mental incompetence to stand trial, with the notion that this is something he was absolutely entitled to do and follow. So much so that allowing the court putting him to the choice of, you can't make your lawyers forego this. You got to take this on your own if you want to make the lawyers forego it, because the lawyers are committed to this. How do those two arguments work together? Or are they just kind of inconsistent? We have to accept that.
Well, it's not that they're inconsistent. The McCoy argument presumes a competent defendant, right? So I agree, of course, with Ms. Merchandani that Mr. Roof, the court should not have found him competent. But once it did, once he was a competent defendant, that came with certain fundamental rights, or rights that he had the choice to decide what to do and how to be master of his own defense. I mean, McCoy uses this sweeping language about being master of one's own defense. And so one of those rights, and we think it squarely fits under McCoy's program language, is the choice whether to depict oneself as mentally ill. And again, Reed cites all of these cases and talks about why someone might not want to do that and why that might be fundamental to a person. So this isn't some sweeping, we're not asking the court to endorse a broad reading of McCoy like the courts in the Taylor case.
Yeah, so let me interrupt you because
Yes.
you said the magic word for me is a broad reading of McCoy.
Yes.
Now, of course, defense lawyers know it better than I'll ever know it. The things that McCoy lists that are for his client. Guilty, jury trial, testify, no appeal. Quick summary of a war, but that's enough. But you get my point. But what about the Fourth Circuit's cases like Chapman and Sexton versus French, which is a capital sentencing case? What about those two cases that don't they kind of bind this panel?
They don't bind this panel, and also they're not on point. And so let me address both of those points.
Well, what about Sexton versus French's presentation of evidence in capital sentencing as a classical tactical decision left to counsel? Okay, go ahead.
Well, so Sexton versus French, of course, it was a 2254 case, so a very different procedural posture and inquiry. And the question there was whether the attorney needed to consult. The defendant was complaining, not that he had disagreed, but that the attorney hadn't consulted. So this was really more like the Florida versus Nixon line of cases that the Supreme Court distinguished in McCoy. Chapman, of course, was about what we would absolutely agree is a day-to-day tactical decision, whether to accept an offer of a mistrial. So we don't think that they are on point. But beyond that—
I thought Chapman dealt with calling witnesses too. Didn't Chapman deal with calling witnesses also?
Your Honor, I apologize. I don't recall that point. I believe—
Okay, and my notes may be wrong. My notes may be wrong. Suppose for a second it did say calling witnesses is a classical tactical decision left to counsel even when the client disagrees. Part of that's a quote, part of it's not. But suppose that is in Chapman for the purposes of this question. What do you say about Chapman and its effect on this panel?
Well, I don't think that affects the overarching question of what's a fundamental decision, because of course the defendant also has the right to choose whether or not to testify, and that could be seen as a question of calling witnesses. So we know that there are some decisions—
Well, that's a pretty unique thing, right? The right to testify or not testify. I mean, there's plenty of case law out there that says just what Judge Benton said, which is tactical decisions about who to call and not to call are just that. They're tactical decisions. That's different from the right to remain silent or not to remain silent. Wouldn't you agree there's a fundamental difference between defendant testifying and decisions about other people being called or not called?
We think that a defendant has the right to just define his overarching objective, and that is a fundamental decision. Now, once he has defined that objective, it is within the attorney's discretion to decide what witnesses to call and not to call, but the attorney cannot undermine that overarching objective. And I would also just, in response to Judge Benton's question, point the court to the Smith versus Stein case out of the Fourth Circuit, where this court said McCoy, just kind of fundamentally rewrote the rules on the balance between attorney and client. So I think that the reasoning of Sexton and Chapman has been undermined by McCoy. Really, they take an outdated view of counsel as the master, where instead it's the defendant who's the master and counsel who is the assistant.
Well, the master as the final objective.
But the fundamental—
The master as the final objective.
In the sentencing phase, wasn't the fundamental objective presumably to avoid the sentence of death and get life instead? I mean, that's got to be the fundamental objective of the sentencing phase, isn't it?
That would seem reasonable, Your Honor, but that is precisely what the Supreme Court rejected in McCoy, because of course, Mr. McCoy's attorney thought that as well. Mr. McCoy wanted to avoid the death penalty, and his attorney said, that's okay, that's your overarching objective. I now get to call all of the shots about how we get there. And the Supreme Court said, no, the defendant had a higher objective here, something that was more important to him, that he was willing to risk death for, and that was not admitting these particular facts. That is just like Mr. Roof's case. He did not want the death penalty. That was not his goal, but he told the court point blank, I have a higher objective here. It is more important to me to not present myself as mentally ill. And once he said that, his attorneys were obligated to abide by that objective.
I get to the question of, in McCoy, of course, it was a question of whether you're going to admit guilt or maintain your innocence. Here, if the objective is to avoid the death penalty, you would think that it's a strategic decision of whether is it best to avoid it by putting on evidence of mental illness or not, which would put it in the lawyer's hands if he had insisted on if he had had lawyers at the penalty phase as opposed to waiving it. I mean, you're making the equivalent of McCoy's guilt or innocence the same as the tactical decision of whether to put on evidence of mental illness. Now, do you have any case that links those two?
Well, I'd like to respectfully disagree with the characterization of McCoy, Your Honor, because in McCoy, Mr. McCoy's attorney strenuously contested his guilt. It was the admission of the facts, the actus reus of the killing that was the problem. And we know this because not only does the majority talk about this, but Justice Alito talks about this in his dissent. If it had just been a question of admitting guilt, then the Supreme Court's prior case in Brookhart versus Janus would have controlled, and it would have been an easy question because an attorney cannot admit the practical equivalent of guilt. So we believe that McCoy is talking about the defendant being able to have an overarching objective, and that objective, one possibility, is to avoid admitting certain facts, and that Mr. Roof's case squarely fits within this. I see my time is coming down.
Yeah. Well, I do have another question, if my colleagues will permit me. You've relied very heavily on Reed, and I wanted to ask if the distinction that we heard earlier from Ms. Mercedani doesn't play in here. She was quick and right to correct me when I said insanity defense, because there wasn't an insanity defense here. It was, technically speaking, it was mitigation evidence about mental illness in the sentencing phase that we were talking about. But Reed is an insanity defense case, isn't it?
It is. It also,
and that's a distinction with a difference, as was noted by your co-counsel a few minutes ago, because insanity defenses, in effect, admit the act and admit guilt, but say no legal responsibility. In other words, it is a statement with immediate, under the legal construct, immediate legal consequences, right?
It is, Your Honor, but I do think Reed parses it out and says it is not just because of that. It is also because of potential stigmatization. And it cites to other cases, including, I believe it was the Treese case, that talks about these sorts of admissions possibly undermining the reasons that a defendant had for committing his offense. We've also cited, and this is in our reply brief, to the State versus Tribble, the Vermont Supreme Court, where it was talking about a diminished capacity defense, which is a little bit more similar. So we do think that there is
you say the fact that it's an insanity defense and it has immediate consequences is not really a distinguishing feature in your mind. It's that it's really important to the defendant. That's the thing that matters.
Not just that it's important to the defendant, Your Honor, that this is the defendant's main objective. And we think it's fair to consider whether that is a reasonable objective, right? It's not just any old objective. It's not that I don't want my attorney to wear blue. I mean, you know, you could come up with all sorts of unreasonable objectives, but the courts have repeatedly found that not wanting to present oneself as mentally ill because of possible stigmatization is reasonable. And so we do think that that this fits squarely under McCoy and its program language.
Thank you.
If there were no further questions on the McCoy point, I would like to move on to the future dangerousness point. Your Honors, at the government's urging and over the defendant's objection, the court entered an order broadly precluding Mr. Roof from presenting as mitigation evidence of the conditions of confinement that he would be subject to if he were sentenced to life without parole, the only alternative to a death sentence. The government then capitalized on this absence of evidence it had itself secured and argued in its penalty phase summation to the jury that Mr. Roof's two mitigating factors about his lack of future dangerousness and his ability to be safely confined if spared were, quote, not true, because he might incite others to violence through use of the prison mails. Now that argument was misleading because, and nobody disputes this point, there exist security measures at any correctional facility that would prevent the sort of letters the government was asking the jury to envision from ever seeing the light of day. But no one told the jury. And when they keyed in on the government's incitement by mail argument during deliberations and asked the court if it was relevant to the lack of future dangerous mitigating factors, the court, over the defense's objection again, refused to answer. It told the jurors to just reread the mitigating factors and use their common sense. Jurors were thus left with the misleading, indeed false impression that Mr. Roof could not be safely confined if he was sentenced to life without parole, and that they should reject these two mitigating factors for that reason. Individually and cumulatively, these errors violated Mr. Roof's right to a reliable penalty phase based on accurate information and a sentencing body that could give effect to his mitigation.
Excuse me, are these mitigating factors 8 and 9?
Yes, Your Honor.
Well,
That's exactly.
The court didn't exclude those, did they? I mean, Roof submitted those as additional mitigating factors, and the court allowed those.
The chronology here can be a bit confusing, so perhaps if I might assist the court, let me take the court through it a little bit. So what happened in this case is several months before trial, the government sought early disclosure of the mitigating factors that the defense would proffer. And this was back at a time when Mr. Roof was represented. Now, the Federal Death Penalty Act doesn't require this, and the defense raised constitutional objections to it, but nonetheless, the court ordered early pretrial disclosure. So the defense submitted a notice of proposed mitigating factors. And in that notice, they included two mitigating factors about how Mr. Roof's individual characteristics and the characteristics of his crime, based on those, how the life in prison would be more onerous for him. The government then filed a motion in limine. And as part of that argument, and they argued that those two mitigating factors should be struck. And as part of that argument, what the government urged the court to hold was that evidence of prison conditions, including prison security measures, are not relevant mitigation. And they in particular also argued that they are irrelevant to future dangerousness. And this is at 471 of the joint appendix that they make this argument. So then Mr. Roof comes back or through counsel and responds, well, wait a second, general evidence of prison security measures is relevant to future dangerousness. Let's be clear on that. But court, you don't need to go there. That's not what we're talking about. That's broader than the court needs to consider here. These particular factors are individualized to Mr. Roof. We don't need to talk about prison security generally. Now, this issue having squarely been presented by the parties, the court nonetheless writes this broad order saying details of prison administration are not proper as mitigation, full stop. So given that context, that the relevance of this evidence to future dangerousness was specifically before the court, we think it's clear that Mr. Roof was at that point by the order precluded from presenting this evidence. So then,
well, I'm sure the government's attorneys are going to speak for themselves, but I understood the government's response to be that kind of breadth is not a fair or an appropriate reading of the government's order. Of the district court's order. Judge Gergel was saying you can't start talking about prison conditions as a way of trying to say, look, it's going to be particularly good or bad for him based on BOP policies, but that nothing in that prevented you from coming forward with evidence that was very specific about what was going to, specific to Mr. Roof, your effort to say, look at all the protections that there are associated with BOP policies, that doesn't speak to the issue that you wanted to speak to more specifically. Now, I understand you disagree with that, but what is it that makes you say that we should accept your assertion that this reading of Judge Gergel's order is the right one, that he meant to say you can't talk about the prison, period, full, as you put it, full stop? Why is that the right reading?
Well, I wouldn't presume to suggest what the court meant to do, but I would point the court to two things. First, the plain language of the order, and then to the context that led up to it. So the plain language of the order, and I'm looking at 493 to 494 here. It is inappropriate to ask the jury to imagine conditions at some imaginary prison. Details of prison administration are not a proper matter for a capital sentencing jury. They are too speculative. And the court is precluding as mitigation evidence that would speculate about defendant's future conditions of confinement. And
right. That all of that, I agree. Those are the exact words. And what the court seemed to be saying is, I don't want you speculating, and that seems to be what the concern was, that you were going to say third parties might do this, and if third parties did do this, this is how the prison would react in some prison where he does go to, and that would all be too speculative, and I don't like that. Now, why is that the same as saying that you can't present evidence that's specific to the defendant on trial and relevant to the specific defendant's ability to adjust to prison life?
Well, so the evidence that Mr. Roof would have needed here to address the government's argument that it made in summation was general prison security evidence, right? It was individualized in the sense that it was about Mr. Roof's future dangerousness, but it was about general prison security measures that would have prevented him from ever sending out a letter like the one that the government was asking jurors to envision, right? And in Lawler, which of course postdates the court's decision, so it did not have the benefit of Lawler versus Zook, but Lawler says this kind of idea about generalized evidence not being relevant is a red herring, right?
Well, counsel, let me, because again, that's what I'm interested in, is the extent to which Lawler guides us.
Yes.
And let me ask you this question. The court does say in Lawler, you're right what it says first, but then it immediately says the evidence must connect the specific characteristics of the particular defendant to his future adaptability in the prison environment. Now, that's where Judge Gergel was right, because you've got to connect particular specific characteristics of defendant to future adaptability, and not just some overarching speculation about whether you're going to be in a medium or the lowest level of security, or whether you're going to be in the highest level of prison, right?
Well, so there were two decisions here. The first was to exclude the mitigating factors that Mr. Roof had proposed about how prison would be particularly onerous. And we think that was wrongly decided. But whether or not it was, in issuing its order, the court made this broader statement after the parties had briefed whether this sort of evidence was relevant to future dangerousness, excluding this general evidence that Lawler very clearly says is relevant. And I don't believe this is a point of dispute between the parties. With Lawler in hand, I think everyone is in agreement that evidence of general prison security measures would be relevant to this issue that the government raised of whether Mr. Roof could incite others to violence through use of the mails.
But you still got to connect them to the, like 9 does. 9 tries, I think, I shouldn't presume. 9 says this, given his personal characteristics, safely confined. You know what it says. Don't you have to do that? Don't you have to do that even under Lawler?
Well, I think that presenting evidence of prison security measures that would rebut a suggestion of an act of future dangerousness is sufficiently particularized, and that seems clear from Lawler. We also have, I believe it would be Simmons, right? That was general evidence about whether someone would be eligible for parole, and that general evidence was relevant to future dangerousness. So I don't think there's any dispute as to the relevance of prison security measures to the factors presented in 8 or 9. But beyond the evidentiary issue, Your Honors, we have a separate issue here, because the government then, in summation, misleadingly told jurors that Mr. Roof could not be safely confined because he might incite others to violence through use of the mails. And it made this argument couched in vouching language, saying that Mr. Roof's mitigating factors were simply not true. And now the government, no doubt, was aware that basic mail screening procedures exist at any correctional facility just to prevent this sort of dangerous mail from getting out. The jurors, however, would not have been aware of that and likely would have deferred to the prosecutor, a law enforcement official who they would have assumed would have expertise on this matter. The jurors, yes.
Usually when we talk about vouching, we're talking about vouching for sometimes what a specific witness might say or something like that. Here, it feels like you're using that term a little loosely to say we don't like what the prosecutor said because it was broad enough to be interpreted as saying, you know, that there's nothing that could be said in this. Whereas what the prosecutor said is that's not true. And you could read that as saying what prosecutors and defense lawyers say all the time, which is you shouldn't believe what they say. I'm disagreeing with them, and here's why. If we cut it as finely as you're asking us to cut it, wouldn't we be holding both prosecutors and defense lawyers to a pretty impossible standard, which is you can't disagree without being at risk of being told you've lied to the jury and are vouching? Because what the prosecutor said is it's just not true that you can make this guy safe. We think there's danger.
Well, that's right, Your Honor. The prosecutor didn't simply say, we disagree, you look at the evidence, we think it points in one direction. The court repeatedly used the simply not true. There are some factors that are truth. There are others that are not true. These two are not true. And we do think that is vouching language and that is appropriate to hold the government to that standard. But the vouching issue aside, yes.
In spite of the double negatives, the prosecutor liked the double negatives, as you know, by the way that they state the issues. Despite that, suppose that they were improper for a second. Boy, isn't this minuscule and the big thing here, the factors that we must go by, let's say the Wilson factors, I'll call them just for short. Is it this no prejudice?
So the court's referring to the United States versus Wilson case where they go through the Darden factors. So the Darden test isn't applicable here. Those factors perhaps may be informative, but this is the impairment of an enumerated right, Mr. Roof's right under the 8th Amendment to a reliable penalty phase. And so the Darden test is not the right test here. It is harmless beyond a reasonable doubt that the government needs to prove. And the Donnelly versus Cristoforo case is what tells us that.
Yes, you're right about the environment, but you know, even in Wilson, it was talking about a denial of due process, but let's don't go there for a second. Address the kind of factors and whether there's prejudice.
Great, Your Honor. So of course, first and most important, the prejudice inquiry is one that puts the burden on the government, and they have to prove it beyond a reasonable doubt. And not just that, they have to prove beyond a reasonable doubt that this didn't contribute to the verdict of just one juror, because of course, that's all it took in this case. So why can't they show that? Well, a number of reasons. First of all, we think that Lawler versus Zook tells us that they can't show that. And of course, that binds this panel. In the Lawler case, in its harmless error analysis, which was under the much more difficult Brecht standard on habeas, Lawler said that because the jurors issued questions that showed they struggled with how to determine future dangerousness, the court was left in doubt about whether they understood it. And that alone was their basis for finding that the error was not harmless. That makes sense, both as a general matter and also specifically in this case. As a general matter, we know from empirical studies that we cited in our opening brief that future dangerousness is the single most important consideration for capital sentencing jurors in just making their decision. So we know that future dangerousness is not a minuscule question. This is actually an incredibly important question, and the jurors should have received scrupulously accurate information on it.
The standby counsel for Mr. Roof stated that they were planning to put on an expert witness about the fact that he wouldn't be dangerous if he were confined to prison. And they didn't put that proof on, did they?
So what counsel said in that pleading, and of course it was a pleading that Mr. Roof did not join. This was part of the competency request that counsel made, was that if Roof hadn't self-represented, then counsel would have put on a sort of Dr. Cunningham type expert, this kind of risk assessment where the defendant is evaluated and his risk level is presented. But they drop a footnote there, Your Honor, that says, and also, but for the court's order that precluded general prison conditions evidence, we would present that. So, so counsel and Mr. Roof alike felt precluded from presenting the evidence they needed here because of the court's order. But to go back to Judge Benton's question about the prejudice here, it is incredibly important that of the 3 questions that jurors sent out during their penalty phase deliberations, 2 of them were on this particular issue, right? 2 of them asked, Your Honor, what do we do with this incite others to violence through the mail argument that the prosecutor raised, right? Is that relevant to future dangerousness?
Can I ask you this, Ms. Yates? Yeah. At that point, did defense counsel come forward and say, Your Honor, this is the point at which we're not, we understand the court's earlier ruling, we think, but here's where we think we would like to talk to the jury about the mail screening that's available, about Bureau of Prison regulations that would control his ability to communicate. Is there anything like that where the district court heard that and said, I'm just not going to let you put in anything about that?
So there were several objections made. Mr. Roof first immediately objects, right? Even Mr. Roof, this impaired 22-year-old with no experience in the criminal justice system, when he hears the government make this argument, even he recognizes the unfairness of this and immediately objects. So then closing argument concludes. And
objects and says what?
Objects and says that this was not proper argument, that he didn't think that it was a reasonable inference from the evidence.
He objected to the argument that he would be dangerous. I'm asking you a specific question about, because the argument you made earlier and what you've just repeated is they all understood, they being defense counsel and Mr. Roof personally, that they just couldn't put in any evidence to address this argument. And I'm asking whether anybody sought a clarification from the court, raise the issue again for reconsideration if they thought they were right. Was there anything like that?
Yes, Your Honor, that's what happens next. Right. So then the summation concludes and Mr. Roof again objects, and he specifically says, Your Honor, this is unfair. I was precluded from putting in this evidence. It's not fair that the government made this argument. And the court rejects that. And then says, I disagree. I don't think I precluded you from presenting.
There you go. Right. The court says, I didn't stop you. You could. The court has a view of what the court said, which is very different from what the defense seems to think. And the court is saying you were able to do this.
I mean, the plain language of the order is what it is. I mean, I think the government's argument is, well, Mr. Roof, despite the plain language of the order, should have understood based on the context that led up to it that it didn't really mean what it said, and that he somehow needed to renew his objection that this sort of evidence was relevant to future dangerousness at some later point. But the context leading up had involved the precise question of future dangerousness. So I don't really understand that argument, candidly, Your Honor. They did then ask for a curative instruction, right, telling the jury that Mr. Roof was not permitted to introduce evidence of conditions of confinement and that they should disregard incitement through the mail. And then, of course, we have the juror questions that come. And the jurors ask these questions, and what the court does is nothing. And what that did is it deprived Mr. Roof of the ability to have the jurors consider his mitigating factors, because it effectively converted them into aggravating ones. And we know that the government's argument hit its mark, because on the verdict form, for these 2 factors, the jurors wrote 0, that no juror had found in favor of him.
Okay, so when this argument that they converted the mitigating into aggravating, I've puzzled over this a little bit, because it almost seems that the defense is arguing that the government is not entitled to rebut. The government is not entitled to respond to a mitigating factor. Here, the mitigating factor was put in front of the jury, and the government said, don't believe that because it's just not accurate, and you shouldn't accept it. And then and here's why you shouldn't accept it. And then your argument in response is, well, you've turned it into an aggravator. Is the government bound to stand silent in the face of your mitigation evidence, or are they allowed to rebut? And if they're allowed to rebut, how do they avoid the argument you're making now, which is you've unfairly converted a mitigator into an aggravator?
It wasn't the government's argument that converted it. It was the court's refusal to correct the jury's misimpression that Mr. Roof's mitigating factors went this far. And we know that that impacted them, because if it was just about his ability to, or risk of personal violence, there was no dispute on that point. The government wasn't arguing that. In terms of what the government was allowed to do, I would point this court to the Wilson case that Judge Benton mentioned earlier. In that case, what happened was the government had what the Wilson court called an 11th hour surprise. In summation, the prosecutor there asked jurors to draw an inference from the record that the defense could not have reasonably anticipated. That was the problem in Wilson, and they found that was prosecutorial misconduct and reversible for it. That's exactly what we have here. There was no way you could have anticipated that they were going to respond to your mitigation factor by saying that's not so. There was no way to anticipate based on the evidence that they had presented. So when the government's penalty phase case closed, it was not apparent to the defense, nor could it have been, that there was a need to put on evidence of prison security measures that could have kept Mr. Roof from sending this sort of inciting mail out. That was not apparent. The only evidence that the government points to that might be related is this testimony of Lauren Knapp. It begins at 6178 in the record. This was a jail official. And what she testified to was that Mr. Roof had been in pretrial custody for, I think, approximately 2 months. He had not written any letters up until that point, but he wrote his first one. And as part of her job, she was screening his incoming and outgoing mail. And Ms. Knapp testified that she read this letter and she thought it concerned her that Mr. Roof might be suicidal based on what was in it. And so she spoke with her superiors. They put him on suicide watch. They searched his cell and they found this jailhouse writing, what the government calls a manifesto. And she proceeded to read that to the jury. Okay, and then she testifies in response to the government's final question, what did you do with the writing? And she says, I gave it back. We gave that back to Mr. Roof. That is the sum total of the evidence. Now, we would dispute this inference, but could a reasonable inference from that evidence be that Mr. Roof was writing this in the hopes of sending it out to incite violence? Okay, that possibly. There is no reasonable inference that could be drawn from that he ever could. His mail was being screened, and we know as a pure factual matter, he could not. I mean, that is not disputed. The jury simply was misled to believe that this could be released. Right.
So really, there's two things that to try to put a point on this. For you to win on this, we have to accept that the government's argument was improper. That is, that making statements about future dangerousness in the aftermath of the court's ruling was a surprise and improper. And we also have to accept your argument that the district court's ruling was a blanket refusal to allow any comment on prison security measures. Those are two key factors for you to win on the arguments you've just presented, right?
Those are 2 of 4 errors that we have presented that are interrelated here. The exclusion of the initial.
And if you lose on those 2, you can't win the argument you're making, right?
No, I disagree, Your Honor. I think okay. I think any one of them. First, the exclusion of the 2 mitigating factors that were individualized to Mr. Roof would be an error. But I'm focusing more on the error of excluding the evidence, and the plain language of the order clearly does. Then separately, even if this court disagrees with that, under the United States versus Wilson, it was inappropriate and misconduct for the government to come in summation at this 11th hour and make this claim, which was, there was evidence that could demonstrably rebut it that had been precluded, that the juror was misled on. Separately from all of that, even if those up to that point were not errors, when the jury came back under Bolenbach and said, we are expressing clear confusion on this crucial issue of future dangerousness, and the judge refused to clear away the confusion, then that was also an error. So they work together. I mean, certainly all of them together, we believe, deprived Mr. Roof of a fair penalty phase and the ability to have a jury properly consider his lack of future dangerousness mitigation. But individually, each one would merit relief. Does the court have further questions on this? If not, perhaps I could reserve the remaining time as part of my rebuttal.
Yes, Ms. Bernice will do that.
Thank you, Your Honor.
And thank you. Ms. Adams, I understand you're to argue next for the government.
Correct. May it please the court. I'm Ann O'Connell Adams for the United States. Today, I'm covering the questions related to competency, self-representation, and the penalty phase. So that's questions 1 through 14 in our brief, and it's all of the questions that appellant's counsel covered. My co-counsel, Bonnie Robin Vergeer, is prepared to cover the guilt phase questions if the court has questions about those. I know they were not part of the defense presentation this morning. Unless the court has a different preference, we can begin with competency. The district court did not clearly err in finding Roof competent, and it should affirm unless the district court's finding is arbitrary or unwarranted. Ample evidence supports the district court's competency finding. First, Roof had a rational and factual understanding of the nature and consequences of the proceedings against him. The district court noted his high IQ, his ability to describe the proceedings in detail, and no expert said he didn't understand the proceedings.
Well,
second,
hold on, Ms. Adams. Why don't you just go straight at Ms. Merchandani's argument that there was just a fail. The district court just didn't engage on this, didn't address the substantial number of witnesses and evidence provided by the defense that this defendant, didn't matter whether he was a really smart guy, he was a really, really ill man and incompetent, incapable of actually assisting in his defense. Please just go straight at that assertion that the written record fails to show that Judge Gergel did the weighing required to be done to make this competency decision.
Judge Gergel at the first competency hearing heard 6 witnesses testify for Roof, including Dr. Maddox, who testified that Roof was incompetent to stand trial. His written order goes through all of the evidence that was presented at that hearing and rejects it in favor of Dr. Ballinger's finding that Roof was competent, that he understood the proceedings against him, and that he had the capacity, the ability to assist counsel if he wanted to. Counsel is pointing to a lot of reports that were submitted with as an attachment for the motion for a second competency hearing, but none of those reports spoke to a change in competency since the first hearing, and the court has those reports. So you have them, we have them.
Right. But their assertion is there's nothing that shows that the district court gave them a fair hearing, a fair consideration. They were, as the defense puts it, roughly speaking, dismissed out of hand. Why is that reading of the record inaccurate or unfair?
Well, at first it's not unfair because none of these reports, all of these reports were submitted right before the penalty phase. They weren't submitted with—
I'm assuming you mean it's not fair, not that it's not unfair. Here we're caught in the double negative world again, but
it wasn't unfair for the district court to not look at those new reports if he didn't in fact look at them, which I think the record indicates he does, as did Dr. Ballinger. And that's because none of these reports that were attached to the motion for a second competency hearing spoke to a change in Roof's competency. The motion for a second competency hearing before the penalty phase was based on a representation from defense counsel that facts arising after the first competency hearing showed a change in Roof's competency. And none of the reports that defense counsel were trying to submit spoke to that change in competency. Counsel mentioned a few times the report of Dr. Moberg. Dr. Moberg evaluated Roof in February 2016. It was almost a year before the first competency hearing. There was no mention of Dr. Moberg, that they couldn't get Dr. Moberg there in time. Dr. Moberg's report wasn't submitted at the first competency hearing, even though Dr. Moberg had all of the information available to him. The other reports as well.
Well, they said, now tell me if I misunderstood, but that Moberg's report wasn't done at the time of the November hearing, did not yet exist. Is there, I'm quoting them, did not yet exist. So
it did not. It did not yet exist. I mean, I think none of the experts, I think the fact that there was a competency hearing caught Roof's experts off guard. Dr. Lofton tells you in the affidavit from Cyprus, I'm here in Cyprus without my files because I wasn't expecting there to be a competency hearing. And I think that shows that these experts that had been meeting with Roof over the course of 14 months or however many months it was leading up to the trial, they were prepared to testify in mitigation that he had autism, or that they were prepared to diagnose him with other things, but nobody thought he was incompetent. And I just want to clarify about whether Dr. Ballinger read the reports. Judge Fenton has the citation for where Judge Gergel says he read them, and he doesn't go back and say that that was an error and he thought he had them before the first hearing. Dr. Ballinger says in his second competency report at JA 5978 and 5979, he lists all of those reports as reports that he read in preparation for the competency hearing. He confirms in his testimony at JA 5602 and 5603 that he did read them. There was some confusion about that. And then a significant amount of Dr. Ballinger's second competency report is about a discussion that he had about those reports with Roof. He says when he showed up to the prison, Roof had Dr. Lofton's report. He had them all printed out. He had them highlighted. He wanted to talk to Dr. Ballinger about them. So there can be no question that those reports were actually considered, at least by Dr. Ballinger. Now the court could say, I don't want to look at what's in these reports because they should have been submitted back in November.
Well, the court could have said that, but didn't say that, right? What the court said was there's law of the case. And the law of the case is a specific legal doctrine that bears on legal issues. And how does law of the case have anything to do with whether or not the district court could consider these things?
I don't think that law of the case, Judge Gergel did say that there was no objection at the time to whether this could be this was a proper use of law of the case or anything like that. But
yeah, whether they objected or not, though, whether they objected or not, if that's the basis on which he made his decision, isn't that an error? I mean, isn't that a clear error to say it's law of the case that I looked at this before and therefore I can't look at it again?
No, we say in our brief, we're not trying to defend the use of the law of the case doctrine. What Judge Gergel was doing was saying, I've already found in November 2016 that Roof was competent. This motion that was filed for a second competency hearing was based on a representation that counsel had noticed changes since November that called his competency into question before the penalty phase. And he said, this is not a redo of the first hearing. We're not going back to, come up with all the evidence that you didn't come up with back in November. We're going to assume he was competent in November 2016. And I want you to tell me during this hearing of any evidence you have that there's been a change in competency since November. And we cite a case in our brief, the Adams case, that says a judge, when he makes a factual finding, can say, this factual finding is a finding that I'm going to let sit for the rest of the proceedings. So we don't think this was like a technical application of the law of the case doctrine. Judge Gergel was entitled to say, you're telling me there's been a change in his competency, so let's see the evidence of the change.
You agree it was imprecise and inaccurate and wrong, right? Say the words law of the case about facts.
We don't think law of the case applies.
I take that as a yes. Proceed.
Yes.
Okay, go ahead.
Defense counsel is arguing that Roof did not rationally understand the consequences of the proceedings against him and could not cooperate with his attorneys because of a delusion that he was going to be rescued from prison by white nationalists. But Roof confirmed that he understood there was a high likelihood that he would be sentenced to death and the chance of being rescued was very small. Dr. Ballinger testified that Roof didn't have a shred of doubt that he faced a risk of death, and the district court credited that testimony. Roof was not making an irrational calculation that his best way to stay alive was to keep out the mental health mitigation evidence and then be rescued from death row. Dr. Ballinger testified that his concern was he didn't want his act to be discredited. He stood by what he did. He had no regrets about his crime, and protecting his reputation was important to him, whether he lived or died. That is, there's testimony about that from Ballinger at JA 1061. The district court
let me interrupt you for the other thing that got me during Ms. Merchandotti's argument. She mentions the Anton and Wooden case several times. Just checked. It's really in her brief a lot. I don't think you even mentioned the cases. I could be wrong, but it's not in your index and I didn't see them quickly there. Do you want to comment on Antoine and Wooden?
I don't, is it the proposition that somebody can be delusional? Like if a person is delusional, then
It's just if you ignore a lot of defense evidence, you can get reversed.
Yes, and the district court didn't do that here. So there's two competency hearings, and I want to make that clear. So the first competency hearing, Roof had 6 witnesses, and the district court goes through in a comprehensive opinion and addresses each one of those witnesses and, you know, says whether it's crediting their testimony or not, and making a finding that it's crediting Ballinger. And the witnesses that Roof put on, there was, you know, none of them were making a diagnosis that Roof had any kind of a delusional disorder. They noted some symptoms of psychosis, but nobody said, I'm diagnosing him with this particular delusional disorder. Dr. Lofton says at the second hearing, you know, she thinks attenuated psychosis is an appropriate diagnosis.
There's no evidence of a somatic delusion in this.
Well, there is. And so the somatic delusions, so Dr. Ballinger says, I don't think those are probably delusions. Those are probably the result of an anxiety disorder. But the somatic delusions, even if they're delusions, are not evidence of a broader delusional disorder. So, and those delusions, you know, everybody noticed that they were happening. Defense counsel saw that, heard about these delusions. The experts heard about these delusions. Nobody thought that that was evidence of a broader delusional disorder or showed that Roof was disconnected from reality. And certainly those particular
you couldn't read the defense reports to indicate and the pleading from the defense side to indicate this is as Ms. Merchandani put it, this is a part of a broader pattern, a larger picture of a deeply disturbed human being.
Well, no, I don't think that any of the defense experts were saying he had a delusional disorder, that he was disconnected from reality, that he was stuck on this belief that he would be.
Well, I'm sorry to interrupt, but when you say there's nobody said that, maybe I thought they were saying, and I've heard it repeated here today, that they were saying this guy had a delusion that he was going to be the man who starts the fire. He's going to start the race war, and sure, he's going to pay a price in the short term, but his brother neo-Nazis are going to come get him out of jail, and it's all going to be for the greater good. And he's willing to pay the price because this is going to save the world for the white race. That's his worldview. That's his fixed view that drives everything he does, and that's delusional. Now, that's, I understand, and I haven't done it justice, I'm sure. They said it better than I did. But when you say nobody said he was delusional, on the contrary, I keep hearing them say, oh, this guy's delusional, all right. And this is his delusion, and it's a fixed delusion, and it drives everything, and it represents incompetence because he can't assist in his defense because he's got this fixed and bizarre view of what the future is going to be. So respond to that. Why is that assertion from the defense one that just doesn't have any traction, and one that the district court wasn't obligated at the second hearing to address more fully?
Well, I think the first point is, even if somebody is having a delusion, that delusion has to render the person incompetent to stand trial. So it has to connect back to, do you have a rational and factual understanding of the proceedings against you? And do you have the ability to consult with your counsel to a rational degree of understanding? So, if Roof is reading a lot of white supremacists,
their argument is he doesn't have the ability to connect with his lawyers because he won't engage with them on it. He just cuts them off and says, no, you can't say anything about this that would indicate that I'm not well. I don't want you to say a word about it. I refuse to engage with you on this. Does that not hit the competency issue?
I think the question is whether that is because a mental disease or defect is causing a delusion, like a fixed false belief that he's going to be rescued from prison only if the evidence is not introduced, that is preventing him from cooperating with his lawyers. And that there is evidence in the record, lots of evidence in the record to suggest that is not what was going on here at all. Roof's experts that testify about that delusion, Dr. Lofton says in her affidavit, I'm prepared to diagnose him with autism spectrum disorder. I also once heard him say he's going to be rescued from prison. But Dr. Ballinger is the only person who explores that idea with Roof. And Roof says, Dr. Ballinger said, this is not a delusion. He wasn't stuck on this. He was able to joke about it. He's able to accept other information and admit that even though this is something that he thinks would be really great if it happened, he's not counting on it. He understands that the chances of it happening are very low. This is something that you'd probably read in white supremacist literature on the internet. Dr. Ballinger testifies that there's no psychotic process here, that Roof has no disorganized speech, no abnormalities, no inability to maintain eye contact, and that he wouldn't be able to fake that during the absence of psychosis, during sustained interactions over multiple days. And he also says he wouldn't be able to fake that absence of psychosis on 3 different tests that were administered to him and that showed no psychotic disorder. And, again, the experts are saying we noticed symptoms of delusions, but none of them are willing to say that he has a delusional disorder, that he's disconnected from reality. Dr. Maddox was the only expert to testify. She thought he was incompetent because this idea that he was going to be rescued from prison was preventing him from cooperating with his lawyers. The district court addressed that in its opinion and rejected it and credited Dr. Ballinger's summary of it instead, that, I tested this out with him and that is not a delusion that he's stuck on. He doesn't have any kind of a delusional disorder. I want to just point to one thing that came up in the presentation from the defense counsel, which was the assertion in the reply brief that defense counsel acted diligently in bringing this to the court's attention because it wasn't until he stopped cooperating that competency was in question. And I just want to dispute that. If really there had been all this evidence that Roof was stuck on a delusion, he was going to be rescued from prison, counsel is arguing that that also prevents him from understanding the proceedings against him. So if he didn't understand the consequences of the proceedings, then this is something that should have been brought up before the eve of trial. I think it just all goes to the district court's consideration and the justifiable skepticism of the idea that there was even a need for a competency hearing to begin with, given that all of these experts had been evaluating him for months and hadn't brought up the issue of competency at all. Unless the court has further questions on competency, we can move to McCoy. The McCoy issue is whether Roof had a Sixth Amendment right to instruct his lawyers to withhold mitigation evidence. And McCoy did not fundamentally reshuffle the division of decision-making authority between the lawyer and the client. As we've gone over, the defendant gets to decide whether to plead guilty, whether to waive a jury trial, whether to testify, and whether to appeal. The lawyer gets to decide what arguments to make, what witnesses to call, and what objections to make.
Well, Ms. Adams, that can't be precisely right when you say which arguments to make, because in McCoy, there is, you can frame that as making arguments. The defense lawyer deciding, I'm going to admit the act because there's a way I want to argue this, and the Supreme Court says, no, you don't get to do that, because that's a fundamental objective of the defense. So I'll ask you what I asked Ms. Yates, which is, help us understand the line between what's a tactical decision and what is a fundamental objective of the defense. And why are you right in saying that this is just, you know, the mental illness stuff is just tactical? And why are they wrong in saying, no, this is a fundamental objective of defense, particularly in light of your own argument a few minutes ago that Roof said from the beginning, this is like absolutely basic to him. He does not want any evidence of mental illness to come in. It represents the break with his lawyers. It's of utmost importance to this defendant. I don't think the government can dispute that, right?
No, I think that's right.
Okay, so how is that? Help us understand then where the line is between tactical decision and fundamental objective of the defense, and why this, which is clearly uppermost in this defendant's mind, is not a fundamental objective of the defense.
So when McCoy talks about the objectives of the defense, it doesn't make any broad statements that, you know, the defendant gets to decide just, you know, in a broad ranging way what the objectives are of his defense. It cites to ABA Model Rule of Professional Conduct 1.2 to talk about what are the objectives of the defense. And those say that, you know, you talk to your client about whether to plead guilty, whether to waive a jury trial, whether he wants to testify, and you have to follow what he says on those. And in McCoy, we know that included in that is, do you want to admit your guilt at trial, or do you want to maintain your innocence, which we think goes right along with the decision whether to plead guilty. But it doesn't go broader than that to say the defendant just gets to decide in general what he wants to accomplish from the hearing. So Roof takes a very broad view of what that means. He says in the opening brief.
I don't want to. I'm sorry to interrupt, but I'm trying to have you help us with the analytical point. There's may not be an exact, easy to draw line, but can you? I mean, we know what Roof argued because we've read the briefs and we've heard the argument today, and you've even acknowledged that this issue of not admitting mental illness is something that is just as important as it can be to him. And as Judge Gilman's earlier questions indicated, you know, it's like, and I shouldn't put words in his mouth, but it's what it indicates to me is that this was also real basic to whether he's getting the death penalty or not. So if that's the backdrop here, what makes that not a fundamental objective of the defense? What do you point to say that's just tactics? At this point, it's all tactics.
Well, I think we can certainly point to Fourth Circuit precedent, and Sexton versus French. The Fourth Circuit says what evidence to present in a capital sentencing hearing is evidence is a tactical decision that's best left in the hands of counsel. But I think more broadly, in a capital case, in addition to those four things that the defendant is getting to decide, whether to plead guilty, to testify, to waive the right to a jury trial, whether to appeal, he can also decide whether he wants to try to get life imprisonment. And that's the goal that that was communicated to his lawyers. They tell us that at JA 574 and 662, they said, he's told us he doesn't want the death penalty. That's the goal we're working toward here. He offered to plead guilty in exchange for life imprisonment, and he decided on a trial rather than pleading guilty and going to the penalty phase because he wanted to create appellate issues. And so I think in a case like this, where his goal that's been communicated to his attorneys is he wants to avoid the death penalty. I
thought the record here was a little contrary to that he said, and I quote, "If people think I have autism, it discredits the reason why I did the crime," and then says, you know, wrongly lumping autism in with his many other issues. But then he also seems to just continuously say, it's better to die than to be considered autistic because I don't want people to think I'm not a fully perfect specimen, as he put it. I mean, if doesn't the record reflect that he's prepared to die rather than have this evidence go in?
Yes, but I think if the court adopts a position that the defendant gets to say that and change the objective of his defense based on what evidence his lawyers are planning to put in, then that essentially gives him control over the strategic and tactical decisions that belong to the lawyer. He can't say, my objective is to avoid the death penalty, but not if this piece of evidence comes in. Then he's got complete control over the lawyer's realm. In this case, it's, I'd rather die than have my lawyers say that I have autism. You know, in the next case, it could be, I want you to make the case for life imprisonment, but there can be no implication that my mom was a bad mother. You can't tell them.
How is this different from McCoy, where the lawyer said, where the defendant says, I don't want you to admit that I shot these people, and my aim is not to get the death penalty, and the lawyer says, okay, but the best way to do that is what I want to do. I want to admit that you shot the people. I want to admit you killed the people, and then that's going to be better. And the Supreme Court says, no, you don't. That's at that point. We're not just talking about the tactics of how to get to the objective. That is the objective. That the objective is to avoid admitting you did that. In this case, his objective is to avoid admitting in any way that he's a less than perfect mental care. You know, he's fully competent and not autistic. What's the logical distinction? How would we distinguish this from McCoy?
You distinguish it from McCoy because McCoy is about admitting guilt. McCoy is so closely related to one of those 4 decisions that the defendant gets to make that if he decides he's going to plead not guilty and go to trial, then his lawyer can't, you know, override that decision if he wants to maintain it throughout the trial by saying, my client is guilty. My client did this.
Speak to Reed. Distinguish Reed.
Well, so the insanity defense, Reed, similarly, is similar to a guilty plea. When you assert the insanity defense in the federal system under 18 U.S.C. 17, the defendant admits the actus reus of the crime. And also in Reed, the consequences of a successful insanity defense are indefinite commitment to a mental institution. And in McCoy's terms, now, McCoy, the defendant didn't say, I want to avoid death at all costs. The court said it's logical to hope for some chance of acquittal rather than putting the, no death, that you won't get the death penalty over that, which is what McCoy was doing.
The Ninth Circuit didn't just confine itself to the legal consequences of an insanity defense. It said that a defendant, an insanity defense should not be imposed on a defendant when, in ellipses, the defendant wants to avoid the risk of confinement in a mental institution and the social stigma associated with an assertion or an adjudication of insanity, that those things are all still present. So it looks like the Ninth Circuit wasn't just looking at the legal fallout of an insanity defense, but was looking at the fundamental problem of institutionalization and social stigma. Isn't that exactly what Roof is arguing here?
It is one of the things that the Ninth Circuit looked at, but it's our view that that stigma alone is not enough to place the decisions in the hand of a defendant. That just gives him the ability to control what evidence to introduce and what arguments to put on. That if you're looking at stigma, it has to be in terms of defining the defense objective. So in McCoy, the decision is, are we admitting that you killed these 3 family members, or are we maintaining your innocence? In Reed, the decision is, are we saying you did this, but you're insane and you're going to the mental hospital? But a defendant's desire to just avoid opprobrium outside of the specific context of admitting guilt or deciding what that objective is of what the lawyers are trying to do for him, we don't think McCoy should be extended there at all.
You just disagree with Reed, right? You heard the language Judge Jordan quoted to you.
Well, we disagree that stigma on its own can be a reason why the defendant can seek to leave evidence out or not raise a defense. I think you can distinguish Reed based on the fact that an insanity defense is similar to a guilty plea, and also based on it's a decision about the fundamental consequences of what happens if that defense is successful. Which
by the
is
way,
that
Ninth Circuit reads that you got to leave out the guilty plea, because they say even when the worry about the guilty plea is absent. You know how the sentence reads.
Yes.
Yeah.
Yeah, and we think that, I mean, we do think that you can distinguish it based on the guilty plea and the consequences of it, but that just stigma alone is not enough to allow the defendant to make decisions. You know, in the next case, he could be saying, I don't want you to tell the jury that I filed for bankruptcy. I'm very ashamed of that. Or my objective is to come out of this looking like a good mom. You know, he says in the reply brief, my objective was to just come out looking like I'm not mentally ill. Those are not the types of defense objectives that the defendant should get to declare and make his lawyers work toward. The lawyers are there to you know, work toward avoiding the death penalty if that's what their client wants, and that's what these lawyers were doing. The district court laid out the Fourth Circuit precedent on this. So you've got Chapman, which was about the authority to accept a mistrial offer. So it's not the same issue that's going on here, but Chapman gives a really cogent explanation of the decision-making authority between a lawyer and a client. It says that this is not just a typical agent-principal relationship in a criminal case. That's how Ruth saw it. He says, I think my lawyer should just do what I tell them to do. But Chapman tells us in a criminal case, it's different. The defendant has to make certain decisions, and it's those 4 decisions that we've talked about multiple times. Even if he can usually delegate those to an agent, he has to make those decisions. And then the lawyer makes the strategic and tactical calls, even if a principal could normally draw back the agent's authority over those. And then, of course, in Sexton versus French, the Fourth Circuit, you know, and I agree that the defendants hadn't voiced an objection to the evidence that was introduced in that case. So in that sense, it's more like Florida versus Nixon than McCoy. But the Fourth Circuit tells us in that case that it views decisions about what mitigating evidence to present at capital sentencing as tactical decisions that are best left in the hands of counsel. The Smith versus Stein decision that's quoted in the reply brief, it does not say that McCoy fundamentally reworked this division of counsel between the lawyer and the client. And the Supreme Court in McCoy, you know, that case is just deciding that McCoy doesn't apply retroactively. There's no, you know, analysis of whether it's reworked the relationship between the lawyer and the client in terms of decision making. McCoy doesn't undermine those Fourth Circuit precedents. It clarifies that the decision whether to maintain innocence at trial falls in the first category of decisions that the lawyer gets to make. Roof is also focused, you know, in the brief, and it was repeated in the argument, on a quote from Ferretta that it's the accused defense and counsel is merely an assistant. And that quote is repeated in McCoy. But of course, that's followed by decades of precedent that divide the decision-making authority in criminal cases between the lawyer and a client in a way
To
that
be sure I didn't misunderstand something you said in passing, McCoy applies to this case on direct review, right?
It does.
Proceed.
That's correct.
I think you said it didn't apply retroactively. I think you meant
It doesn't apply retroactively, but since Roof's case is on direct review, it applies to his case. And I think it may be helpful to just walk through what happens if the client and the lawyer have an intractable conflict on a strategic or tactical decision. And the dissent in McCoy kind of walks through this, and I think it's very helpful. If the client has hired his own lawyer.
Counsel, this is all from the dissenting opinion, right?
That's correct.
Okay, what authority is it before you get too carried away?
Excuse me?
What authority is it? How powerful is it? How persuasive is it if it's in the dissenting opinion?
It's not, you know, it's not binding. It's not even, it's just a walking through what happens if there's a, yeah. So if the defendant has hired a lawyer and as they're leading up to trial and talking about strategy, it becomes clear that they have an intractable conflict over how to proceed, then the defendant can fire that lawyer and hire somebody else that's willing to go along with what he wants to do. If he has appointed counsel, he can ask for a new lawyer. He doesn't necessarily have the right to it, but under 18 U.S.C. 3006A, the court can substitute in appointed counsel in the interest of justice. I'll point out Roof didn't ask for new counsel and hasn't made that an issue on the appeal. And the judge mentioned that it would be futile. It's that the judge said if I were to replace counsel today and bring in another set of lawyers, we'd be in exactly the same position. Roof had 4 experienced capital defense lawyers who refused to follow Roof's instructions here according to their professional responsibility and filed a brief confirming it was their understanding that this was their decision. the lawyer might, in some circumstances, decide to go along with what the defendant is suggesting. And we see that in a couple of the state court cases, People versus Emiscua and Flores, Taylor versus Steele. And courts have generally said that if you make a record of it and explain why you're doing it, that wouldn't be ineffective assistance of counsel. Of course, the lawyers here said, we're not doing that. And then also the defendant, in order to solve this autonomy problem, can represent himself, which is what Roof did here. The court says in McCaskill, to preserve actual control over the case he chooses to present to the jury, a defendant can waive the right to counsel and represent himself. And so, you know, if a conflict develops and the defendant, it's too late for him to hire a new lawyer, or he hasn't taken steps to protect that, he can represent himself as Roof did here. But no court has said that the answer is counsel has to follow the defendant's instructions. And I think that to give the defendant veto power over evidence that he finds shameful or doesn't want his lawyers to introduce gives no guidance to lawyers about what decisions they get to make and what decisions are up to the defendant. I think you're going to start involving the court in those decisions of professional judgment. That's the whole point of the defense lawyers being there. There are no further questions on competency or on McCoy. We can move to future dangerousness. There were two issues going on here. First was whether Roof could present evidence that other prisoners would abuse him in prison as mitigating evidence. And the court said no. The defendant—
And we read that, and frankly, they didn't spend much time on that. So why don't you engage Ms. Adams on the point that they have chosen to press here at oral argument, which is the district court made a broad statement that no prison conditions evidence was to come in, and the government then sandbagged and used that same kind of prison condition evidence to further its case in saying he was going to be dangerous going forward. Just take that head on, please.
Yes, I think the background is important to understand how the issue developed and why Roof may have been confused about it. So in the decision on the motion in limine with regard to those two mitigating factors that other prisoners would abuse him, the court said, no, that's not coming in. And it said, you know, it's inappropriate to ask the jury to imagine conditions at an imaginary prison, and these details of prison administration are not a proper matter for a capital sentencing jury. It was saying that with respect to Roof's mitigators, that he would be abused in prison, and that was a reason to impose a life sentence.
But it has the flat statement, no evidence speculating about, I'm paraphrasing, but not awful close, no evidence about speculating about Roof's future conditions of confinement of sentence to life, period.
Yes. And then Roof, after that ruling on the motion in limine, Roof provided notice of the future dangerousness mitigators that he is pressing today. And so if Roof thought that he wasn't allowed to present evidence on those future dangerousness mitigators, it would be a little odd to then introduce them after the court's ruling on the motion in limine, or at least to get clarification on what evidence he could and could not present in support of them. Standby counsel told us in the district court, in the pleading that we've cited, it's JA 52, 51, and footnote 6 there, about what they had in mind for those mitigators that Roof was going to forego or planning to forego at the sentencing proceeding. And it was to be expert testimony about Roof's good behavior in prison and his likely future as a nonviolent offender. And they even named an expert, James Austin, PhD, who would get on the stand and testify about that. Counsel said we would also put on expert testimony of how bad life would be for him in a special housing unit, but for the court's order. And so, you know, Roof's counsel says with respect to those mitigators that counsel wrote that they were expecting to introduce evidence that Roof had been behaving himself well in prison. And that is what the prosecutor was countering. Roof was free to put on evidence that he had been behaving himself in prison. The prosecutor said, well, that's not what's happening. He's actually sitting there continuing to make racist writings and you know, having no remorse for his crimes. It wasn't evidence about an imaginary prison. It was evidence about Roof's behavior while he's sitting in prison. The prosecutor—
But it has to be, I mean, just by its very nature, there's got to be a little bit of speculation going on, right? Because the issue is future dangerousness. And so in the context of future dangerousness, there had to be some projecting of what was going to happen. And that was necessarily going to have to be some question or some forecasting of how the prison system could or couldn't control future dangerousness. No?
Maybe. I mean,
Well,
there,
when you
I
say
guess,
maybe, help me understand
because
how could there be questions about future dangerousness about a person in prison? Unless you are talking about prison conditions.
well, I think the idea here that defense counsel is focused on is the insinuation that Roof could send these letters out and that the prison would be able to intercept them. But I think what became clear when they were talking about the jury notes was that incitement doesn't have to just be sending the letters out of prison. You could also be talking to your fellow prisoners and trying to convince them to be white supremacists or harm Black people or take action. And Roof can communicate with other prisoners where he is in Terre Haute. He can talk to the people in the cells around him. He can communicate with other prisoners during exercise and all of those things. And so this is relevant evidence to whether he would be dangerous in a prison. Now, if Roof wanted to then put on evidence that, no, if I do those things, they'll, put me some other place where I can't communicate with prisoners. Well, he should have asked whether he could put that on. I mean, the district court's motion in limine with respect to other mitigating factors did have statements that you couldn't put on general evidence of prison conditions, but he never sought to clarify like that he wanted to respond to this evidence with with something saying that, well, they'll be able to control me, they'll be able to put me in solitary, they'll be able
Counsel,
to.
I've got to interrupt you because didn't the jury ask that? The jury says safely confined. Does this include these writings getting out of prison? The jury asked it. You're
jury
putting it
did
all on
ask
the defense lawyer. Go ahead.
The jury asked it, and but I want to point out these are mitigating factors that Roof submitted. So the language of them was written by Roof's counsel when they were still representing him, and those are the ones that were submitted to the jury. And the jury may have been confused about whether the mitigating factor just referred to Roof himself, like physically harming someone, or whether incitement counts. And when they talked about it, the district court looked at it. It said he would pose no significant risk of violence to other inmates or prison staff if imprisoned for life. And Roof said, I think you should tell them that it just means that I won't personally harm people, not incitement. And
as long as you're on it, what was the district court's obligation with respect to that question when it came forward from the jury?
Well, the district court is not obligated to clarify any instruction in response to a jury question. I mean, I think the district courts say all the time, just read the instruction.
Counsel, we're in the Fourth Circuit, though. You've seen these older cases in the Fourth Circuit said there's a mandatory obligation to clarify jury questions. I bet you know what I'm referring to.
We've cited cases in our brief saying this is an abuse of discretion standard. That the court, these were mitigating factors that Roof provided himself. And the government's argument when the jury came back with the question was, well, why would you limit it when it was broadly written? Like, we put on evidence showing that he could incite other people. And so for the court to come back now and say, no, it just means Roof himself would physically harm people wouldn't be fair. That's not the way that we read the mitigating factor. And so we put on other evidence of it.
Well, they've made the argument, Ms. Adams, that may have been their mitigating factor, but you hijacked it. Not you personally, but the government hijacked it. The government took that factor, and in the course of the unfair sandbagging they've accused the government of earlier, indeed misrepresented the state of the record by saying that's not true, when in fact there was evidence about prison conditions that would bear on whether he could be safely confined. So this kind of, I take it that their view is this all works together. There's a failure by the district court to actually engage with the jury when they're confused. It's a confusion that's created in part by the district court's broad ruling that leaves them thinking they can't do something they ought to be able to do. And then it's further compounded by the the government saying things that are inaccurate and unfair, particularly in light of the Judge Gergel's ruling. Now, help us understand why, at least with respect to the jury question and the case that Judge Benton has referred to, I remember that's a civil case, but like there's a statement that no, if the jury is clearly confused about something, you're obligated to help them with that confusion. Why are they wrong in saying these things ought to be considered together, and when considered together amount to a reversible error?
Well, I think I'd like to push back on the idea that the government did anything improper here.
You should push back on that. And don't assume that we're believing that you did something improper. We may or we may not, right? But just so you understand, it's clearly understood that you don't think you all did anything wrong. I'm just trying to get you engaged directly with that argument about look at all these things together, judges, look at it together.
Well, I'll just point out the government's whole discussion of these mitigators is at 6697 and 6698 of the record. The government could hardly have said less about them. It said these mitigators are going to appear on your verdict form, which they were because Roof submitted them, and Roof didn't address them, and he's continued to engage in bad behavior in prison. That's basically all the government said about this, all of which was correct. And Roof was submitting those mitigators, and so the government had the authority. It could put on witnesses to talk about how he was behaving in prison in order to address what Roof might say about them. The government went first. So
why is it not vouching? They've accused you of vouching when asserting that it's not true that he could be kept safe in prison.
Vouching is about the prosecutor stating that he or she knows that the defendant is guilty or knows that a witness is telling the truth. The prosecutor here, when using the words true and not true, was saying, some of these mitigators are true, like Roof is 21 years old when the offense was committed and had no significant criminal history, et cetera. And then others are not true, and followed that up with a description of the other mitigating factors Roof had submitted on which he presented no evidence, including that he had the possibility for redemption and these future dangerousness mitigators that we're talking about. When the jury came back with the questions, the Roof himself submitted the language of these mitigators, or his counsel did, and then he went with them during the penalty phase. And the first one, he would pose no significant risk of violence to other inmates or prison staff if imprisoned for life. If the district court was going to go back and narrow that based on what Roof was telling them he wanted them to do, well, that just means that I personally wouldn't hit somebody, like I personally wouldn't cause the damage, as opposed to inciting other people to act. I mean, that's not what the mitigator said. So the district court certainly didn't have any obligation to come back and say that. What the district court said was, use your common sense, read it as written. And I think what's important to point out here is that Roof is telling you that he failed to put on evidence about his good behavior in prison or whatever it was he wanted to put on because of the court's ruling on the motion in limine on those other factors. But in reality, he wasn't planning to put on any evidence at all. That's what his lawyers told us. That's why they were trying to intervene and prevent him from representing himself. And it's not really until today that I even have a clear understanding of what it was he wanted to present. And if it's evidence that the government could intercept, or the prison could intercept the letters that he's trying to send, or put him in solitary confinement or whatever, then I would assert that absolutely under the harmless error standard of review, there's no possibility that the jury could have come to a different conclusion. If he's not going to put on evidence that he was behaving,
no possibility that the jury who sent specific requests out to the court to say, help us understand what this means, future dangerousness, help us straighten this out. There's no possibility that if that had been responded to, one juror might have said, you know what, I think this guy's going to be okay. I don't think he has to die. I think this is somebody who can be kept safely in jail. There's no reasonable prospect of that.
No, I think the confusion that was caused here was caused because Roof submitted these mitigators and then he put on no evidence in support of them and said nothing about them. It was only the government that was putting on the evidence. And so to the extent that Roof then said he wanted the mitigator to be narrow, I mean, these were his mitigators. And what he's saying now is, I would have told the jury that, yeah, I'm continuing to misbehave in prison and keep up my racist writings and write letters that say other people should take action against Black people, but the government would, the prison would have been able to deal with me. Well, I don't think that that's very mitigating, and I don't think that that would change the mind of any juror. This crime was extremely aggravated. It involved months of premeditation, multiple victims, especially vulnerable victims, and intent to incite violence, unimaginable loss to the parishioners' families. Roof murdered based on racial hate. He targeted a church to magnify his impact and demonstrated a lack of remorse. And so the idea that the court, excuse me, should vacate a death sentence based on a dispute about a mitigating factor that Roof made no attempt to prove, and that he's telling you today, all he would have done was say, yes, I misbehaved myself in prison, but the prison can deal with that. I don't think there's any reason to remand this case for a new sentencing hearing based on that argument.
How do you specifically distinguish, the case I think that both my colleagues are referring to as Price v. Glosson Motor Lines, which is the Fourth Circuit case where it says, quote, when the difficulty involved is an issue central to the case, helpful response from the court is mandatory.
Well, I think this is not something that's central to the case for sure. This was a mitigating factor at sentencing that Roof didn't make any attempt to prove. If I can find this portion of my brief, I mean, in our standard of review section, we definitely cite cases that say that the district court is not required to go back and give further instructions on a jury instruction if none is warranted. So here, I mean, I think the confusion wasn't caused by anything that the district court did. This was, Roof wrote the language of this mitigator, or his lawyers did, and then he was trying to come back later based on the evidence that had been presented, having made no argument about it at all and presented no evidence about it at all, and said, I think you should narrow it from what you said to say it just means that I would have hurt people in prison, and not that I would have incited other people to do that.
That may have been what he wanted the instruction to be, and the district court certainly wasn't obligated to accept Mr. Roof's proposed clarifying instruction. But in light of the language that Judge Gilman has just quoted to you from this Price case, was the district court under Fourth Circuit law required to say something more than, in effect, I told you what I told you, use your common sense? Was the district court required to give them some further understanding of what future dangerousness means?
No, the court that we cite in our brief is United States versus Smith. The decision whether to issue clarification in response to a jury note is reviewed for an abuse of discretion. And here, if the clarification would have been, I think that no, it includes incitement because it's written broadly, and the government said that. The government.
Well, there you go. You've just given a clarification, right? That's the question we're asking. Was the district court required to do the thing you just did? And if the district court didn't do that, is that a failure under Fourth Circuit precedent?
No, I think if the district court had done that, Roof would probably be here complaining about that. And
certainly, that's unquestionably, that's true. That's their job. Their job is to find stuff to say that's wrong. But the issue that you're getting pressed on right now is on an issue that the jury clearly was worried about because they took the time to write a note and ask about it. Is there a problem under Fourth Circuit binding precedent if the district court does nothing more than say, in effect, I told you what I told you?
No, I think that the Smith case says that that's reviewed for abuse of discretion. Here, it was a mitigator that Roof himself wrote. So to the extent that there's any confusion about what it means, that's not the district court's fault. It's Roof's fault. And, he didn't put on any evidence about it. The district court saying, just go back and read it according to your common sense. I think they could read it how they want to. And certainly if the district court had said, no, it includes inciting other people or, trying to incite his fellow prisoners or sending letters out of the prison, I don't think that would have been a helpful clarification to Roof. Certainly the district court wasn't obligated to make the correction or the clarification that Roof was asking for, which would have narrowed the mitigator beyond what he had submitted.
And you agree if there is an error that under the Federal Death Penalty Act, we have to declare it harmless beyond a reasonable doubt?
That's correct. And for the reasons that I've given, I think this error, the court shouldn't vacate a death sentence based on a dispute about a mitigating factor that Roof didn't make any attempt to prove. If there was really a dispute about whether he could put on rebuttal evidence that he wanted, the judge said, respond to it. You have a rebuttal. And Roof didn't. And he had four experienced capital lawyers sitting there with him. He's free to take their advice or not. But this is a problem that certainly could have been solved at the time with appropriate attention from Roof or from his standby counsel. I don't think there's any chance that the jury would have returned a different verdict if they found that the government could deal with Roof as he continued to misbehave in prison. Unless the court has further questions, we believe that no error occurred with respect to Roof's competency, his self-representation, or his penalty proceeding that would warrant reversal of either his convictions or his death sentence. We ask that the court affirm on all questions. My co-counsel is here prepared to discuss the guilt phase questions, so I'll let the court decide whether you want to hear anything on those.
Okay, well, in that case, thank you, Ms. Adams, and I'll welcome Ms. Robin Vergeer. And Ms. Vergeer, I take it by what your counsel just said, you go ahead and you start your argument. You should begin your argument before I begin directing you. Go ahead.
May it please the court. My name is Bonnie Robin Vergeer, and I'm here on behalf of the United States. I was planning on addressing the questions grouped together as points related to the guilt verdict. These are Roof's challenges to his convictions under sections 247, 249, and 924C, and are covered in the government's arguments, numbers 15 to the end. Obviously, Roof's counsel has not made an oral presentation on those issues, and so I'm fully flexible here.
Well, they may not have, but I've certainly got some questions for you on this.
So I'm happy to go ahead and.
Good. Help us out here with this the challenge to 247. I'm wondering, first off, is it the case that the government has waived any argument under the third Lopez factor, the substantially affects prong of Lopez, right? There's three ways you can make your Commerce Clause hook work. They argued and you engaged on the first two of those Lopez factors, but it didn't appear to me that you had made an argument under that third Lopez prong. And I'm wondering if I've missed something, or if in fact you didn't make an argument on that. And if you didn't argue on that, do you agree that you don't have an argument to make because you forfeited it?
Let me separate out the facial challenge from the sufficiency of the evidence. In defending the facial validity of the statute, we made arguments under all three prongs. So from that standpoint, we've relied on the substantial effects prong as part of it. Certainly, the statute could be applied in situations where there'd be a substantial effect on interstate commerce for a church activity. With respect to the sufficiency of the evidence, the government primarily put in evidence that relates to Lopez prongs 1 and 2. I don't want to say there's nothing that relates to the effects part of the analysis, because
Well, I don't want you to misunderstand my question.
Yeah.
I didn't ask whether there was any evidence in the record that would support an argument under the third prong. My question to you is, did you make an argument?
We
that-
did not make an argument regarding the sufficiency of the evidence
Well,
on the substantial.
let's call it what they call it for a minute, okay? They're making they claim it's a constitutional challenge and that it's an as-applied constitutional challenge. You can call it a sufficiency of the evidence challenge if you like. I'm just going to adopt theirs for the time being, okay? On that as-applied challenge, then I'm hearing you agree that you didn't make any argument that, hey, we can properly go after Mr. Roof because what he did, we have evidence in the record to prove that what he did had a substantial effect on interstate commerce. You didn't make that argument, and so you would be foreclosed from making that argument at this point. Have I understood that right?
Yes.
Good enough.
If your honors like me to start there with 247, I'm happy to do that.
Sure, I would. I would like to understand why your reliance on Scarborough doesn't create real problems in light of Lopez and Morrison. Why? I mean, other judges have said there's some tension there, but you lean on Scarborough very hard, and I take the defense's argument to be, in essence, if that's the rule, then nothing is beyond the reach of the Commerce Clause. Nothing is beyond the capacity of the federal government to reach in and address with criminal law. So that's the argument I would like you to respond to.
Okay. The Scarborough part of our argument is just one piece of the argument. Roof committed his offense using a gun, magazines, and ammunition, all of which had moved in interstate commerce. And under Scarborough and cases in the Fourth Circuit applying that precedent, that places his offense in or affecting commerce. I'm using kind of the whole phrase because Scarborough uses the whole phrase, but that is only one piece of the evidence.
Let's stay with it for a second. So your argument is, if somebody uses a gun in the commission of a crime anywhere, that is a sufficient connection to interstate commerce, that no matter what crime is charged, the federal government's got a hook to come in and take care of it. I'm not talking about the 924C. We're not talking about a gun-focused charge. We're not talking about any gun-focused charge right now. Talking about the hate crimes and the obstruction of religious liberty crimes. The assertion you're making is you used a gun. The gun in it traveled in interstate commerce, and so your terroristic threatening, or your pick some other thing. You know, you had a gun and that moved in commerce. Therefore, Commerce Clause jurisdiction exists. Is that the government's position?
Well, it would depend on the statute at issue. In this particular instance, with the formulation that Congress chose for 247, with the offense being in or affecting commerce, and clear legislative history, and of course, drafting history, because the statute was amended in 1996 for this exact purpose of allowing Congress to punish any conduct that met the offense conduct requirements that fell within its Commerce Clause authority. So this statute would permit Congress to reach a crime that was committed, as Roof's was, with a gun that is moved and ammunition that is moved in interstate commerce. That doesn't mean every statute that would be the case. It would depend how the jurisdictional element was drafted.
So it's all in how Congress says it, because what I hear you saying is the limits of the Commerce Clause are such that if a gun travels in interstate commerce, no matter what crime you commit with that gun, there's enough of a connection to interstate commerce that you can be prosecuted federally. Because what you're saying is, if it goes to the limits of the Commerce Clause's power and Congress says that, the fact that a gun was involved and it moved in interstate commerce is enough.
Well, Scarborough itself allowed a prosecution for possession and emphasized that there did not need to be any present nexus to interstate commerce, meaning the possession itself doesn't have an interstate component, but
because it's about the gun. And I'm asking you about cases where it's not about the gun. The gun-free school zone, Lopez itself, has to do with guns. So if there's a gun in a gun-free school zone and it traveled to interstate commerce, under your logic, Lopez is wrongly decided?
No, because Congress subsequently amended the Gun-Free School Zones Act to add an interstate commerce element, and courts then upheld it. And this court, I mean, the Fourth Circuit in the United States versus Hill, noted the fact that that courts had numerous courts had upheld it after the interstate element was added. But I don't want to give the impression.
I want to ask the question to you a different way, and I think it's a big problem for you, which is in the religious obstruction statute, and I'm quoting, I think, quote, "It's the offense that is in or affects interstate or foreign commerce." The offense. And as you know, that is not the language of the felon in possession statute. It says receives, transports, or possesses in commerce or affecting commerce. Does the fact that it says the offense must be in or affecting interstate or foreign commerce, does that make this different, period?
It doesn't. And this question regarding the offense is discussed in the 11th Circuit's en banc decision in Ballinger. What Congress was getting after wasn't that the ultimate act. In Ballinger is igniting a church. Here, it's of course, shooting all the victims at the church. That the ultimate act is not the only thing that is the offense, but it's the indispensable steps that lead up to it. And in the committee report and the statement of floor managers, they made this clear that as amended, 247B is satisfied whenever in committing, planning, or preparing to commit the offense, the defendant travels in interstate foreign commerce or uses the mail or facility or instrumentality.
They didn't enact that language, though, did they, counsel?
I'm sorry?
Congress did not enact the words that you just read to us, right?
No, but the offense part has to include more than the exact moment, or the whole point of amending the statute in 1996 would have been undermined, because that was the precise problem Congress was addressing in amending the statute. But I just want to back up for a second. I understand the court's pushing back on the gun aspect of this, but we have so many examples of the ways Roof used the channels, instrumentalities of interstate commerce to commit this offense, and certainly taken together, they meet the jurisdictional element. And I just want to go back and cover some of these, because the gun is just one piece of our whole argument. Roof used the internet to research churches in Charleston with predominantly Black congregations and identified mother.
So any use of the internet, no matter temporally in time, how far apart it may have been from the offense, is enough for a jurisdictional hook?
Well, no, I wouldn't go that far, but here he used the internet.
Then where would we draw the line? If somebody got on the internet and wanted to do a search to find, I don't know, gasoline cans because they were going to make a homemade bomb, and then 6 months later they went across the street and planted a bomb at a restaurant that they were angry at, would you say they used the internet, ergo a use of instrumentality of interstate commerce? This is not purely a local crime. This is something that could be charged federally.
I think you'd have to look at all the facts of the case to figure out how integral or important or indispensable that particular use of the channels instrumentalities was. Here, that we don't really have to speculate about that. We know the website that Roof went to. He researched what the Black churches that were in Charleston. He identified his target as Mother Emanuel. There's no speculating here about what the connection is. He also used his home telephone to call Mother Emanuel beforehand. He used his cars in the interstate highway system to scout out Mother Emanuel on 6 different occasions before the crime, and then
let me ask you that. Let's talk on that for a minute too. Uses the car, gets on the highway. Any use of a car, you get in your car and you're in an instrumentality of interstate commerce, you're under the control of the federal government. Is that the government's position?
No, but if you use your car to bring yourself to a church in order to kill people in violation of the statute, then yes, that would be good enough. I mean, for
Why?
example.
Why? I mean, I understand the crime is a horrific crime. That's not really the issue. What we're grappling with here is just the dry technical question of how far is the government's power reach under the Commerce Clause? And is the government's position really, you got in your car, cars are an instrumentality of interstate commerce, you're now within the federal government's reach to regulate criminally?
If you use your car in furtherance of a statute and the interstate element covers it, then yes. And this is not breaking.
So then there's
ground.
nothing. I mean, there are probably some good walking cities in America, but so now you're saying anytime somebody gets in a vehicle, they are now within the limits of the Commerce Clause, and that's something that can be then regulated by criminal statute by the federal government.
Your Honor, let me just point you for just an example, because this is really not breaking new ground. United States versus Mandel in the 7th Circuit, that involved the intrastate use of a car in furtherance of a murder for hire scheme. And the court held that that was within Congress's power to reach. We're not talking about attenuated uses. These are indispensable steps, almost but for causes.
Well, they'd always be indispensable under that logic. They're always indispensable, right? Because you could always say, well, it was a 10-mile drive to get there. It was 10 miles all within the same state, but it was a 10-mile drive. Nobody's going to walk there to shoot their victim. They're going to get in a car and go to shoot their victim. Therefore, every murder is now, or every assault or every threatened assault is now subject to federal regulation as a crime. What do we make of that in light of Morrison and Lopez, where the Supreme Court seems to be saying, hey, the federal government's got a lot of reach, but it doesn't have illimitable reach. The Commerce Clause does have a limit.
Morrison and Lopez did not involve a jurisdictional element. They were just regulations of conduct with no case-by-case assessment of whether the interstate commerce nexus was present. Here we have a jurisdictional element, and the types of uses that we're talking about here, courts have routinely held, this is not novel in any way, have held that these instrumentalities and channels of interstate commerce can be sufficient to tie the conduct, the offense conduct, the evil that Congress was getting at, and tie it so that there's federal authority. I mean, I can't do justice to this point because there's so many examples, but let me just rattle off a few. Threats by use of instrumentalities of interstate commerce, like telephones, have been upheld even though the telephone calls were intrastate. For example, United States versus Coram and in the 8th Circuit, United States versus Gilbert in the 1st Circuit. Convictions for the receipt of child pornography through the internet have been upheld, regardless of whether the images cross state lines.
And all of these things in each of these instances, and we've seen your briefing on this, in each of these instances, the object of the offense could not have been accomplished without the use of these things, as you pointed out. And indeed, the object of the offense was to use these things. You couldn't have transmitted the child pornography without these things, unless, in the modern world. But this seems to, is there no difference here when the assertion is, here's a person in South Carolina who commits a terrible crime in South Carolina, and that's, he's got to get in a car to do it, and he does it. But that's not, you don't see a logical distinction or a legally significant distinction between that and somebody who is transmitting pornography over the internet, and that internet is the jurisdictional basis.
No. The Supreme Court has made clear the substantive elements of federal statutes describe the evil Congress seeks to prevent, while the jurisdictional elements tie the law to one of Congress's enumerated powers. If you contrast the way, basically what Congress wanted to do in 247B is list every possible way a crime could be committed in or affecting interstate commerce, and to make sure that that's covered, and that the federal government could prosecute the offense conduct if that's true. And rather than list them, say, don't use the channels and instrumentalities of interstate commerce when you commit this type of offense. Don't engage in activity that affects interstate commerce when you do this offense. Don't use a weapon that's crossed state lines previously to commit this offense, which is sort of the way the hate crimes interstate commerce portion of 249A2, how that's drafted with list. So Congress doesn't have to do it that way. Congress instead deliberately chose to use a formulation affecting interstate commerce that had come to mean over time through Supreme Court case law as covering the gamut. If Congress could reach it, this statute reaches it. And
Well,
so
explain to me what we're to make of this language from Morrison then. This court has rejected a but-for causal chain from the initial occurrence of violent crime to every attenuated effect upon interstate commerce. If accepted, this reasoning would allow Congress to regulate any crime whose nationwide aggregated impact has substantial effects, etc.
but Morrison was evaluating a regulation of crime in the absence of a jurisdictional element. And so it's sort of looking at the whole picture, going through the analysis and trying to figure out whether or not there was a sufficient regulation of commerce, sufficient either whether it's economic or substantial effects and so on. But here
Understood.
we could
Understood.
deal
I'm
with
just
it
trying
case
to-
by case.
I'm just trying to get you to respond to that specific language. This court has rejected a but-for causal chain from the initial occurrence of violent crime to every possible effect, because then everything is Commerce Clause. Now, how is what you're arguing different from that kind of but-for causal chain?
It's not an attenuated but for causal chain like you had in those cases where you have to follow this whole string of steps to try to come up with how you would have the crime affecting interstate commerce. It's quite direct. He used the internet and found his target. He got in his car and he drove on interstate highways in order to get to the church, in order to kill people there. He used a GPS device and satellites to navigate.
Counsel, does the record reflect how right up the time he entered the doors of the church, he used GPS or not?
Well, the GPS shows when he stopped. I mean, it shows, I want to say that he stopped the car somewhat 20 minutes or so before he got out and actually entered the church. So there's GPS data all the way up to the point where he basically parked the car in the church. So there's no attenuated.
So 20 minutes before?
What?
20 minutes before?
I want to say 7:48 p.m. is the time that jumps out my mind, but I probably have to go back and absolutely double check it. But I think it was about 20 minutes before he entered at 8:16 p.m. or so. So you don't have this attenuated, this leads to this, leads to this, to get to your final. You have this direct use of instrumentalities and channels that are a but-for enabler, facilitating the commission of the crime. And it's very much in keeping with a whole host of other Congress's power to punish mail fraud, even the mailing is only interstate. There's just a wide range of examples where the channels and instrumentalities are the vehicle, the means, and that is what allows Congress to exercise its authority to reach those offenses. Obviously, the time is going through it, and so if there aren't more questions specifically on Section 247, I'd like to have a chance to at least cover.
Let me ask you one area that troubles me a bit: the certification question. You know, it has to be in the public interest, and to further vindicate a public interest to certify under either of these acts, hate crime or the religious obstruction. And the Attorney General did it, but in this case, South Carolina had already indicted Mr. Roof, was seeking the death penalty for these murders. And supposedly the legislative history says, well, the purpose of these acts is to ensure appropriate deference to state and local prosecution and to assume jurisdiction for any reason that unless they are unable or unwilling to secure a conviction. So what's the justification in these cases for the federal government to in effect jump ahead of the state here?
Well, two things, Your Honor. First, there's a preliminary question about the reviewability of the Attorney General's assessment that the prosecutions in the public interest are necessary to secure substantial justice. We don't think it's subject to judicial review. The Fourth Circuit has a decision, juvenile mal number 1, that the Roof team relies on. That's regarding a different statute for juvenile offenses. We don't think it should be extended beyond its context. The Fourth Circuit's an outlier, the only circuit to hold the certification in the juvenile justice area to be judicially reviewable. So our first point is that the question just isn't reviewable, period. Assuming that it's reviewable, the certifications here ought to be valid. I mean, in juvenile mal, the court found a sufficient federal interest in prosecuting a juvenile who allegedly committed 6 particularly egregious felonies involving carjacking and murder. We are way past that here. The federal interest in prosecuting hate crimes like Mr. Roof's is at its zenith in terms of the gravity and aggravation of the offense. And the civil rights violations at issue here. The Attorney General is entitled to make what's sort of a quintessential call from a standpoint of prosecutorial discretion to decide that it's in the federal interest to proceed here.
Is the justiciability, sorry.
And that the South Carolina did not have a hate crime statute.
Well, that's also true. That is a separate basis on which the 249 certification was submitted, was that South Carolina did not have a hate crime law.
Right, but why was it in the public interest, say, on the religious obstruction? To jump ahead of what South Carolina was doing.
Because this went to the core of the kind of crime and offense that Congress enacted and then amended the church arson statute to address this type of highly aggravated obstruction of justice obstruction of religious exercise because of the race of the people who are in there, just basically try to start a race war. And going back, we didn't get to the constitutionality arguments about Section 249, but keep in mind the context in which this is arising. One of the badges and incidents of slavery was that white people had the power to commit acts of violence against Black people with impunity. And as part of maintaining a system of white supremacy, and Dylan Roof shot and killed 9 Black people at Mother Emanuel because they were Black. And he did so for the declared purpose of reestablishing white supremacy. That was the chief badge of slavery in America. If that isn't a sufficient federal interest for the government to come in here and prosecute this case, it's hard to think of what a stronger interest would be.
Well, I can understand a little more on the Hate Crime Act, which is what you're talking about. I guess, what about the religious obstruction?
Well, let me first point out that Roof actually didn't challenge the certification under 247 in the district court, so that issue would be reviewed for plain error at most. But I think the interest here, they merged. This was one offense, that one aggravated crime that violated both the hate crime statute and the religious obstruction statute, and it wasn't any reason to bring one part of the case and not the other. It's a whole package of egregious conduct that the Justice Department ought to be able to come in and bring a case like this. If it can't bring this case, then we've basically sort of thrown these statutes into the dustbin for purposes of being able to move forward on the most important examples of violations of these statutes. If I may, I don't know if
I'm sorry, I got a quick question. This is on this point. You said it's not something that's reviewable at all. Are you saying that it's not justiciable as a matter of constitutional law, as an Article 3 matter, or as a prudential matter? And I'm asking that because if we felt that your argument on the merits was good, but we wondered about your justiciability argument, given certain Fourth Circuit precedent, are we entitled to assume without deciding it's justiciable and hit the merits, or are we on a constitutional bind because this is an Article 3 point?
I think it's a prudential point. There really aren't criteria by which to judge, to make the judgment about whether the Attorney General is right or wrong about whether the prosecution's in the public interest and is necessary to secure substantial justice.
Let
There's
me
no
ask this
criteria
question
to
a
judge
different.
it.
Can I ask the question a different way, the way I think about it? Which is, the United States Supreme Court has said we don't have hypothetical Article III jurisdiction. Clearly, many times, period. But Judge Jordan points out that if it's just a question of not Article III, but prudential or whatever you want to say, case made law, whatever you want to call it, then we might have jurisdiction to even look at it. Would you reply to that point?
We haven't raised a jurisdictional objection. It's just that this court or this panel ought to follow the leads of all the other circuits and all the other courts that have held that the certifications under 247 and 249 are not reviewable. It's not bound to extend juvenile mail to this different context. But even if you do decide to reach the merits of it, I think easily the Attorney General's certifications pass muster. I see my time is nearly up. I want to say something about the 924C, the crimes of violence argument. And let me just because we didn't have a chance to respond to this before, I want to quickly address a new argument that Ruth made in his reply brief regarding the 924C counts with respect to the predicate for 247. Recall there's two predicates here. We only need one. The 247 and the 249 convictions are each, the ones resulting in death are each predicates. And Ruth made a new argument.
What happens if we say, we don't think you've made out a case for federal jurisdiction under those obstruction of religious observance statutes? Hypothetically, we said we're troubled by that. We don't think those stand. But the 924C convictions also have this hate crimes predicate. Are we entitled to say, well, there's still a predicate, so you're okay?
Yes, and in fact, the jury was specifically instructed that it had to be unanimous on one or the other of the crimes of violence or on both, and there's a special verdict form, and the jury indicated that it found both predicates beyond reasonable doubt unanimously, the 247 and the 249 predicates. So the court certainly could rely on just the 249 predicate for the crime of violence. Just to get to
I got another one for you. I know you have things you want to say, and I hope my colleagues won't mind me using your last 10 seconds here, and maybe we'll give you some more. What's the practical effect? Again, assume just for the sake of discussion that we thought there's a problem with the religious obstruction of religious observance counts on the jurisdictional hook, and so they can't stand. Would this have to go back for another penalty phase hearing?
No, it would not. And we addressed that point. We actually addressed the flip side of that point because Ruth argued that if the firearms convictions were thrown out, we'd need a new penalty hearing on the 247 death eligible counts. But the same argument we made, this is the very end of the brief, applies in reverse. Either way, Ruth would not be entitled to a new penalty phase hearing because the district court in its charge and the sentencing verdict form explicitly instructed the jury to consider each capital count separately, and the jury did. So there's no need, they're not tainted. The Tucker and Johnson line of cases that they rely on where the defendant's sentences rested on tainted convictions, that doesn't apply here because the jury made an independent assessment on appropriateness of recommending a death sentence on every count. And so there would be no need to send it back for a new penalty hearing.
Do we on that, now I'm going to take some time, do we on that have to make a separate beyond a reasonable doubt finding as a court or not?
No, it's not a harmlessness question. It's just that the jury, it's just a separate inquiry that the jury was instructed.
Well, there'd be an error under the hypothetical Judge Jordan gave you, if I understood it, there would be an error that the jury heard all about and was given forms on obstruction of religious exercise. That's an error way back there, I get it. And then you're trying to say, well, they were given a separate form to fill out. Do we have to add under the Federal Death Penalty Act do we have to add a beyond a reasonable doubt finding of our own?
I don't think so, but I may not be understanding whether your question is going to the 924C part of it. If your question is, does the fact that the 247 convictions would be thrown out, and now we're asking whether Roof should be sentenced to death still under 924C and J based on the hate crimes predicate offense, if that's the question,
right.
We already have a properly instructed jury that was told that it needed to make a determination on all of the steps of the analysis under the FDPA for every single count. So they've already recommended death as an appropriate punishment under the 924C count. So there's kind of nothing that needs to be gone back and redone because it's already been done.
Your answer is clearly no. Okay.
But as a follow-up here real quickly, how would that answer the defense argument? And I assume this would be an argument, you know, they'll speak for themselves, that you can't, hey, wait, you can't untangle and know that there would have been a conviction on that 924C count if the only evidence that had been presented were the hate crimes piece, not the not argument and evidence associated with the obstruction of religious observance. And therefore you would have to say it's harmless beyond a reasonable doubt to let that each of those 924C counts stand, because the jury hearing the evidence on those first set of counts, religious obstruction counts, did not affect their decision making with respect to the hate crimes and the 924C.
Certainly, if the court thinks that there is any question about whether there could be prejudice on it, any error on the 247 counts would be harmless beyond a reasonable doubt in terms of the jury's consideration of the 924C count. Basically, the jury was told that there's two possible crimes of violence that it could find as a basis for, and then what the jury had to find was that the use of the firearm was during and in relationship to either one or the other of the crimes of violence or both, and they had to be unanimous. They couldn't mix and match. And so given that instruction and given the boxes that the jury checked, I think we could safely assume that that any error regarding the 247 convictions would be harmless beyond reasonable doubt with respect to 924C counts, and there wouldn't be a need to repeat the penalty hearing. And obviously, I realize my time has elapsed, but if I could just quickly point out the one point that they raised as a new argument in the reply brief that I wanted to just quickly respond to because we didn't have a chance.
You better, since we're way over time, you'd better do that in a 28J letter if in response to a new argument in the reply brief, because we are a little over time on that. I know it was our time, but it is the court's time.
Okay.
So I won't apologize too much, but I will give you the 28J escape clause. And then thank you for your argument. It's very helpful. And we're back to Ms. Merchandani.
Your Honors, if the court is interested in hearing more about the issues that you were just asking about, could we reserve 10 minutes of our 15-minute rebuttal time for Ms. Farrand to address the Commerce Clause issues?
Yes, we'll give her 5 minutes. That's how long we went over with her. So we'll have Mr. Farrand for 5 minutes at the end. And then whatever time the judges want after that.
Okay. And I only have a few points to make. So if I have remaining time, if I could cede it to Ms. Farrand, I would like to do that.
No, we gave her 5 clear minutes, but go ahead. You need to talk.
Okay, thanks. During the opening argument, there was a lot of discussion about clear error and Antone and Wooden, which again, the government was unable to really distinguish how this case is different because it's not, because there was substantial contrary evidence ignored. But I want to bring the court back to what I started with, which was the focus should really be on the legal error, which the government clearly admits is what happened, the legal error of blocking 4 mental health reports from the second hearing using the law of the case doctrine. Now, The government admitted it was legal error. And for prejudice, they say it wasn't prejudicial because the reports had nothing to do with Mr. Roof's change in competency between November and January. And I want to say that the change in competency is not what the statute says to look at. The statute 4241A says, is the defendant presently suffering from a mental disease or defect? And then
Well,
it's
isn't that inherent in what Judge Gergel was saying to you, which is if you've got something to tell me, he said, I decided in November he's competent. And if you've got something new to say to show he's not competent now, go ahead. I want to hear it. But if all you're doing is giving me additional stuff to say, no, reconsider what you said before because you're wrong, because here's more information about stuff in the past. And we want you to look at that now. What's wrong with him saying to you, you don't get a do-over. We did it. Now give me some new information, because new information is what's relevant to whether he's competent now.
Well, the statute doesn't have time limits on when things are relevant. It says,
Hold on just a second. So your legal position is the statute has inherently in it a requirement for reconsideration anytime defense counsel want to come forward and say, I got something more I want to say.
No, not at all. I'm saying
That's what it sounds like.
No, let me clarify, please. 4241A says, is the person presently suffering from a mental disease or defect? 4247C1 says, important to that consideration is the person's history, okay? So you come to our case, and in November, the court was presented with as much evidence as counsel could muster in the 14 days they had, and the court was not convinced. At the second hearing, 5 weeks later, which the court granted because there was additional evidence of incompetency that came out during trial, at that point, the question remains, is he presently suffering from a mental disease or defect that makes him incompetent? There is not a time limit on it, and the government makes no mention of San Gerard, Arendas, which are not Fourth Circuit cases, but are competency cases in which second hearings were held and the cumulative evidence was considered.
But hold on a second. So I really do want to, I'm not trying to play verbal games with you. I really want to understand what the legal position you're taking is.
Yes.
Because it sounds like what you're saying is anytime a defense lawyer says, there's more information, it's historical information that we didn't put before you before. We didn't, and whether that's because you didn't have enough time or whatever it is, but this is historical information. It's not information that's new. It's not anything that's developed between the last hearing and this hearing. There's just more we want to tell you about his background, that the statute entitles you to have the court go back and look at that again. Because anytime you come up with something more you want to say, that bears on competency now, and the court is obligated to give you additional reconsideration. If I misunderstood you?
Yes.
Okay, well then help me out.
Okay, the first point is that you're never entitled to a competency hearing. You have to show reasonable cause to believe that you're presently suffering from a mental disease or defect that makes you incompetent. The judge agreed in January, late December, that there was new evidence that showed that he was presently incompetent. Now, this was not a do-over. We were not asking for a do-over, but it happened to be that at the January hearing, information that could not have been provided before. That doesn't mean he was entitled to it. That doesn't mean every case is a redo. It means that once the court has the question before it, the legal question, there is not a time limit. And both in San Gerard and Arendas and the Fourth Circuit in Percy, which is a 1985 Fourth Circuit case, you redo a competency hearing by considering all the evidence that's presented. There's no cutoff for time. The question before the court isn't, has his competency changed? It is whether he is incompetent, period. And the statute says you have to look at the history. And at the first hearing, his history couldn't be presented because Dr. Lofton was overseas. The report that she presented, along with others, was nearly 200 pages of reports that went directly to his current competency. And for the court to block it, which the government agrees was a legal error, that is by itself an abuse of discretion. So we asked the court to remedy that error by vacating the death sentence and remanding his case to the district court for a retrospective competency hearing based on the full record as it was presented at the time.
Thank you, Ms. Merchandani. I took that as an end of argument. Be sure I read your,
yes.
I think I read it correctly.
Yes.
Okay. Ms. Yates, you have rebuttal time.
Thank you, Your Honor. First, a couple points on the McCoy issue. The government suggested that the pre-McCoy paradigm that the dissent in McCoy laid out, that this is something that works just fine, and that there's no concern about that paradigm here. Which of course is a different paradigm. The Smith versus Stein case tells us that McCoy did shift the balance. But I think it's important to focus on what that paradigm resulted in here, because what happened here was a complete and utter breakdown in the adversarial process.
You know, before you go further, I just want you to respond to something, okay?
Yes.
Two things that were said specifically that I would like to hear your answer to.
Yes.
One was, you weren't sandbagged, you knew what was going on, and in fact, the defense must have understood that evidence associated with him being in prison was permissible, because you made a representation of evidence of that character that you intended to put in to evidence. Now, it ended up that it didn't get put in evidence, but there was a representation that was going to be put in, and that representation was made after the district court made the ruling that you complain about so strongly here. So your assertions of surprise and shock are not to be believed. That's the first thing I'd like you to respond to. And the second is that even on your terms, this would be harmless beyond a reasonable doubt, because had it been put in front of the jury the way you described, the response is, yeah, he's misbehaving, and that can't be controlled, because even if you can stop mail going out, even if you put him in solitary confinement, prisoners communicate, and his racist, vile, hateful ideology is intended to incite violence and would incite violence. So would you respond to those 2 points?
Yes, Your Honor. So on the question of future dangerousness, what the government's citing to is record excerpt 5251. And respectfully, I think that I would characterize what's said there differently from how the government characterized it. What the counsel said there, and this was counsel, standby counsel making a motion. It is not one that Mr. Roof endorsed. In fact, he was opposed to them making this motion at the time. But what they said was that they intended to present significant evidence in mitigation, including expert testimony about Mr. Roof's good behavior in pretrial detention, and based on that, his likely future as a nonviolent and compliant prisoner if he was not sentenced to death, and why he could thus be safely managed. But then there's a footnote, Your Honor, and the footnote says, we would also, but for the court's order in that we are referring to, proffer expert testimony of the conditions of confinement the defendant would face in either state or federal custody by this expert.
And their assertion is, Judge, you have to read that in context, because in context, what that means is he's going to be an object of violence himself, and he can't be safe. And this all goes back to the motion in limine. It has nothing to do with future dangerousness. The future dangerousness is the stuff above the line, not the footnote. Why isn't that a fair reading of the record?
Well, because Mr. Roof told us otherwise, right? When this happened, when this issue was raised, this incitement by mail issue, which I don't think is a fair inference from the evidence that was actually presented at trial, when this issue was suddenly raised in summation, Mr. Roof immediately spoke up and said, Judge, this isn't fair. I wasn't able to present this based on your order. And then defense counsel then comes in and says, that's correct, and we need this curative instruction and seeks relief.
That doesn't, I apologize, but that doesn't seem to me to be addressing the point. The point that the government is making is not what Mr. Roof argues after the fact, but that his defense team said before the fact and after the judge's ruling, we're going to put on evidence, and it's evidence that bears on prison conditions. So they knew they could do it. So when you say nobody knew we could do it, there's record evidence there that says, no, they knew they could do it. What's the response to that?
Well, I guess I'm not sure what they're pointing to other than the excerpt that I just read, which expressly said the court's order bars us from presenting conditions of confinement evidence.
Well, maybe we're talking past each other, but it looked to me and it sounded to me like their argument was that below the line argument spoke specifically to one thing and one thing only. Can he be safe in prison? Will he be the target of violence in prison? But that they understood the more general question of future dangerousness would involve evidence associated with prison conditions. And they said they were going to put evidence on about it. They said they had an expert. They were ready to talk about it. They just didn't do it. Now, if you read the document that way, how do you get traction with the argument you're making now?
Well, I don't think that the document can fairly be read that way. At least it is ambiguous. To the extent it's ambiguous, this is really a harmless error argument that would fall on the government, right? About no harm, no foul. This wouldn't have been presented anyways, I think is effectively the argument. But aside from that, the order was issued after this litigation back and forth about whether it was relevant to future dangerousness. And the court apparently wasn't persuaded enough by that back and forth to issue an order that that was more specific. It issued an order that very squarely, let me get to the exact language, because it very clearly, it wasn't this kind of speculative order. It said he cannot present evidence of the BOP's inmate classification and designation process, initial and ongoing reevaluations, services, programs, conditions of confinement, etc. It was quite specific what he could not present. I think any reasonable reading of that order on its plain language, and then especially in light of the context that came before it, where the parties were litigating the relevance of this particular type of evidence to future dangerousness, is that the order precluded that evidence. But Your Honors, sticking with the issue of future dangerousness, if I may, to the harmless error point, the government made some references to some issues that this just is not about, right? This is not about his good behavior in prison. That was not disputed. This is not about whether he was going to incite others within the prison to violence. All of the evidence was that he was a loner. This is about the government's 11th hour argument that he would incite others to violence through use of the mails, right?
Well, when you say through the use of the mails, they did make that argument. But are you saying that their argument that he could incite violence was restricted to that when they talked about future dangerousness, there was no reference or fair inference from their argument that they meant, no, this guy will cause trouble. He'll cause trouble. He will incite violence. And that includes violence within the prison walls, whether or not a letter ever makes it outside the prison or not.
I think the jury's questions indicate that they were concerned about incitement through the mail, at least with respect to factor 9. With respect to factor 8, I suppose it could be read more broadly. The court itself said it didn't read that more broadly, that it thought the best reading of that factor was that it was simply about personally committing violence. Of course, nobody told the jury. And so this gets to the question that the court was focused on about these juror questions, right? Because this is a separate and independent problem that we have here. And this court, although it is an abuse of discretion standard, this court in the Price case very clearly did say that when jurors express confusion on an issue that is of importance, a central issue in the case, then it is mandatory to give a response.
How do we square that with the abuse of discretion standard that there's plenty of language in Fourth Circuit cases says should apply in this context too?
Sure.
And the fact they point out Price is an old case, hasn't ever been followed, has never been cited again, et cetera, et cetera. How do we deal with that?
Well, I don't think the fact that it's an old case makes it non-binding. But as I read the cases, the standard is abuse of discretion in that the court has discretion over how to respond. And if it's perhaps a tangential issue or something that is not, that there's not clear confusion on, perhaps whether to respond. But Price very clearly says when they express confusion on an issue that is central, it is a mandatory requirement to respond. And then we've also cited the Southwell case out of the Ninth Circuit, which held that it is an abuse of discretion to fail to answer a question when it is not fairly resolved by the instructions. So abuse of the discretion is the standard, but here the court abused its discretion by not answering the question at all. Did the court want me to address the McCoy issue?
I
see I'm over my time.
A request for that. Now, if I understood earlier, thank you for your argument, Ms. Yates.
Thank you, Your Honor.
Get that. But if I understood my colloquy earlier with Ms. Merchandani, Ms. Farron, you have requested 5 minutes. You've been on standby throughout this case. You've requested 5 minutes in rebuttal to the government's argument about the merits issues, whatever you want to call it.
That's correct, Your Honor. Thank you. And good afternoon, Your Honors. Margaret Farron. Thank you. I'd like to address a couple of points regarding the argument in our brief that Section 247A2 is unconstitutional as applied to Mr. Roof. because there was insufficient evidence of an interstate nexus here. The government's relying on two bases. I'd like to address both of them. First, they say that his offense was in interstate commerce because before the offense, he used various sort of ubiquitous instrumentalities like highways, the internet, and a telephone. They're sort of trying to broaden the nature of the offense here beyond what the statute 247A2 defines. I want to address the government's claim that because section 247 is trying to extend to the limits of Congress's Commerce Clause power, it therefore is enabled to use fewer words or to provide less explanation of exactly how the conduct relates to interstate commerce. That's precisely the opposite. When in the Ballinger panel opinion and the three-judge panel opinion, and also the dissent from the en banc opinion, it's addressed that actually when Congress is going out to the limits of its Commerce Clause power, it needs to be more clear.
Let's just stick with this though, please, on the limited time we got. Assume we thought, okay, Congress meant to and wanted to get to the very limit of its Commerce Clause powers. Is what happened here, what was alleged and proved, sufficient under Lopez 1 and 2, because they've acknowledged they didn't make any Lopez 3 argument. Is it sufficient to provide the jurisdictional hook for the 247 counts?
Not under this statute, Your Honor. The question of Congress's intent and its power are not separate inquiries. The Lopez Fifth Circuit opinion talks about this. Congress has to be clear to invade state prerogatives to this extent. No. I'm
not being clear, so let me try to be clear. I'm asking you to assume we thought Congress was clear, okay? Assume Congress was clear and they've gone to the limits. Is what was proved here enough under the law to say, yeah, that's within that far out of reach of the Commerce Clause?
No, it wasn't, Your Honor, because under Lopez and Morrison, the one principle that holds through all of these cases is we cannot destroy any limits between what is local and what is federal. And to say that these ubiquitous uses of highways, the telephone, a GPS, I don't think anyone nowadays navigates without a GPS system. I don't think anyone travels basically anywhere without using a car. I don't think we find out almost any type of information nowadays without using a computer. Almost all of our social interaction takes place over the computer, and I don't hesitate to point out we're actually doing that right now. So I don't think that I don't think that these kinds of everyday ubiquitous uses bring him within the scope of the Commerce Clause. And if they do, then there is no more limit, because there could be a murder in interstate commerce, an assault in interstate commerce, these core state law crimes that implicate just the very heart of state sovereign authority over their criminal law are now all going to be subject to federal regulation simply because of the everyday uses of these channels that we all make. And if Your Honors don't mind, I'd like to address the Scarborough point for a second too. The government is, as Your Honors pointed out, I think they're saying that Scarborough justifies, it sort of provides a basis for federal regulation, not only of the gun market, but of any intrastate crime that's committed with a gun, which is just a huge leap. That is really a huge leap, not supported by really any of the cases. I think it's telling the cases they cite are felon in possession cases. Scarborough was not just a case about gun possession, it was about a specific type of gun possession that's very heavily and specifically regulated by Congress and the Omnibus Crime Control Safe Streets Act. It's gun possession by felons. That is a type of gun possession.
Well, let me interrupt you. We understand that, but you got a few seconds left. What would the effect be if we actually agreed with you and we said these obstruction of religious observance counts can't stand? You've heard counsel for the government say it doesn't have any effect because the structure of the jury verdict sheet here required the jury to make independent findings with respect to each and every count, and the 924C counts still stand, and there's a predicate for them in the Hate Crimes Act, and therefore, Mr. Roof's death penalty decision is just as real with or without those 247 counts. What's your response to that?
Your Honor, I strongly disagree. And it's the government's burden to prove beyond a reasonable doubt that not even one juror's verdict as to these counts would have been different. If the religious obstruction counts are out, that means half of the capital counts are invalid and half the predicates for the remaining capital counts are now also invalid. And we don't know which predicate the jurors relied And although, as the government pointed out, they were instructed to find death separately as to each count, they, on the guilt phase verdicts form, answered specific questions as to each one of these 247A2 counts. They went through each one individually, and then at the penalty verdict, they actually only answered one question as to all of them. They said, we, the jury, unanimously find for all the capital counts, the death is the appropriate sentence. So the reality of it is they made a determination that all of the counts warranted death. You cannot separate it out. The government cannot prove beyond a reasonable doubt that not even one juror's vote would have been different.
Okay, thank you for your argument. Judge Jordan, did you get an answer there?
I did, thank you.
Okay, thank you.
Thank
Okay,
you.
that concludes the argument in this case. So case number 17-3, United States of America versus Dylan Storm Roof is submitted for decision by this court. I think we're back to you, Ms. Bornese, to close court.
This honorable court stands adjourned. Sign a die. God save the United States and this honorable court.
Thank you.